All right. I believe we're officially live, but I may not be saying anything for a minute because I want to make sure I'm getting everything right on the tech side. Yeah, looks like we're good. What's up, Tia? I see ya. Not even trying to rhyme there, but you know that's just how it be. So let me get some music going while we're here. Hold up. Yeah, no idea. No idea how many people are going to be here, but that's okay. Because regardless, the recording is going to be saved, and yeah. Okay, let me see.
On December.
Oh yeah. You're right. Let me tweet the link after I get this music. That's too chill. That's not gonna work out. That'll work. Hello to you. Hey, it's good to hear from you. Hopefully everything's going good with any sort of legal situations you may or may not be involved with. I'll tweet out this link. Yeah, it's definitely going to be a bit of a learning curve. Learning how all this works. But it's okay. First time for everything. Alright, let me change this. Let me go. Bada bing, bada boom. We're all in this together now. I'll let y'all look at this ugly mug. Okay. Look here. We're live now. Come check it out. Come hang out. How about that? Yeah. Are we feeling the lo-fi hip hop radio of East to Relax 32? I feel like it's a good reliable, just nice, easy. But yeah, we're here. Appreciate y'all for being here. Excited to get this on. Got it pulled up. I understand. We may have some issues with Megan Cuniff, but hey, if she's got the full video, I'm just gonna go off of that. But yeah, in the meantime though, I have obviously been away, like I said. So if y'all got any updates for me on the case, I may or may not have heard it. Lo-fi says nap time. Okay, yeah. I agree. Yeah, not the sleep chill too. How about this? Let's try chill trap. Oh, I still got caps on. Trap non-stop. No copyright. Y'all are seeing the magic behind the scenes. Oh, congrats on the wedding to me. Thank you, Mrs. Detta Ripple FX. Is there any of these non-stop live? Night drive beats a chill drive too. Let's try it out. Got our Bart Simpson. I think that's Bart, right? Confession time. Never watched The Simpsons. Voice is a little echoed. Is it coming through? Yeah, okay. It's coming through my mic. That's okay. That's my. What's that little robotic? Uh-oh. That may be. Gosh, I have no idea what that might be actually. I will say my number one upgrade item right now is to get a better microphone. That's like no ifs, ands, or buts. Yeah, that's just the top priority because this thing's been good, getting me to where I got to, but they want to upgrade that. So we might just have to deal with it for today because it is coming through here. Yeah. But actually, yeah, when I made my little video yesterday, I was recording it. I finally got to a recording that I liked, and then realized when I went to edit it and chop it up that it wasn't actually recording through this mic. It was recording through the webcam mic, and it sounded terrible. So I had to go back and try it again. So, but we got it done this time, or on that time. But yeah, definitely getting an upgraded microphone. Yeah. Anyway, so yeah, if I'm not talking, it's gonna be largely because I'm kind of playing around with the tech. There's really no way to learn, um, I guess how all this stuff works other than doing it in real time. So I'm out the monitor over here. I got chat pulled up. I got streaming software. I got the stream statistics. I'm a big stats guy. I really like my numbers and my data. So yeah. So yeah, excited to be here. Excited that y'all are joining. It's gonna be a learning experience, but hopefully, things sound good enough that we can proceed with the breakdown. So actually, one other thing I wanted to look up is the Appellate brief. Here's the thing, yeah. While we're getting ready, about to watch the video. Here's the rub on appellate law, is that it's basically won and lost in the. It sounds better now. Okay, good. Yeah, it might have just been a connection thing. I'm plugged in hardwired Ethernet cable, so my internet. I'll show y'all. Oh no, whoops. Okay. Uh-oh. Okay, how's that? That better? Yeah, I've got that down. I'm gonna turn it down over here too. I've got my mic on max. So let me do this. Yeah, I should be able to hear me a lot better now. Perfect. Cool. Yeah, internet speed test. So I'm plugged in hardwire. Yeah, I mean, y'all can see. This thing is whizzing. So, shouldn't have any connectivity issues. But like I said, might have some hardware issues here and there. But it's just stuff I'm going to get fixed over time. And yeah, microphone, that's definitely number one thing. So, what was I? Oh yeah, Tory Lanez, Appellate, brief. So yeah, just kind of while we're chilling, hanging out, waiting to get into the video oral arguments. Quick idea on kind of how appeals work is they're basically won and lost in the brief itself. Like I've heard, so back in law school, I did a summer clerking for actually a state Supreme Court justice, and that's all appellate law. And the entire summer I was there, we handled probably 40 or 50 cases, and only 2 of them were actually argued in court orally. Every single other case was decided on the writings, on the briefs. So the brief is way more important than the oral arguments that we're about to witness, but the oral arguments kind of, in a perfect world, it's going to be a good summation of what's presented in the brief and summarized and presented in a very expeditious manner. Because as you can see, the brief here is 98 pages long, and that's kind of been why I haven't covered the appeal yet. Here, let me do this. I haven't covered the appeal yet, mainly because to truly fully cover, and y'all know on this channel, I've been covering this case. I've been following it personally since the trial itself, but as far as my coverage on the case, I like to be as thorough as possible and really go through stuff fully, not just giving you clips that I think are relevant, because I don't want to hide the ball. I want y'all to see. I want y'all to see exactly just the full picture, the big picture. And of course, naturally, you may see my dilemma here, where we've got a 98-page brief that if I'm going to give you the full picture, we'd have to go through the entire 98 pages, which maybe we do. Maybe we do that on the next stream. But yeah, we'll see how today goes, I guess, with the oral arguments. But beyond that, I see. Looks like we got 13 people here. Honestly, I was expecting maybe like 2 or 3 people. So this is awesome. Thank you all so much for being here. Let's do a quick check-in in the chat. What video, when did y'all, I guess, find out about me? Which video was it? Was it the Abba and Preach response video, Charlemagne the God? I've had a couple. Yeah, I've been waiting to hear my take on it. Yeah, you know, yeah, me too. I've been waiting to give it, but kind of as I mentioned in the video yesterday, it's been crazy. It's been a crazy busy last month or two, but thankfully things are settling down. Got the new job, going great with that. Did the whole wedding, had my honeymoon, and so yeah, we're rocking and rolling with all that. Hold on, let me do this too. We're rocking and rolling. We'll get back to all that, but yeah, so we're back now, and like I've said, the plan is to live stream at least once a week, but at the very least, right, shooting for Sunday afternoons, and just check in. Like, so for example, Tory Lanez case, we'll check in on it every single week, just any updates that we can get out of it, or any new information that we might be getting, maybe not through the courts, but through somebody else. Like, for example, that's what I had pulled up here to maybe for us to watch, was I saw clips of this DJ Academics getting deposed, and oh, you can't see it. Yeah, DJ Academics getting deposed, and it was some comedy gold. And good, but it was good. It was good information, and I think it'll be worth it to go over that somewhat as well. So actually, Rock Nation looks like he's live right now. Oh, it's private. Never mind. Sorry, when I had the video pulled up, he was live, but
what you want to do is save hundreds.
But yeah, there's just been pretty much nonstop information coming out, and yeah, I wanted to wait until I can give you the full breakdown, but yeah, that's what we're doing today. So just saying, I see Abba and Preach. Yep, that one, that video, yeah, definitely was funny. The academic stuff. Yeah, no, I agree. Yeah, we'll probably watch that after the oral argument. So yeah, so Abba and Preach though, that video, that was a good one. That was a lot of fun putting together, responding to those guys. Crystal Nicole, finally, yes, finally we are here. Everybody else though, so we got kind of started following up on this channel with Abba and Preach. Oh, AK posted the whole thing? Okay. Yeah, we're gonna have to get into that later. But anyone here from the Charlemagne the God video? That I think that one did the most as far as views goes and subscribers, and yeah, and I got copyright struck on that, so actually couldn't even collect any ad revenue. And I had just finally got qualified to start collecting ad revenue, and that was the first video I uploaded after that. And then the Breakfast Club decided it was a violation of copyright to react to their content, which, by the way, it's totally not. Copyright law is it's a very clear, specific area of law, an area of law I'm very familiar with, and specifically fair use, and how you can use copyrighted material, but if you use it fairly under the 4 factors of fair use, it's not copyrighted at all. So I actually submitted my own appeal when I got copyright struck. I submitted my own appeal to YouTube, and basically pulled the old I'm a lawyer card, and I actually know this stuff. So yeah, y'all don't want to go down this path with me. And then it got removed. So I guess Breakfast Club didn't want to have that fight, which yeah, fine by me. I'm good either way. But anyway, but yeah. So I think the first thing I wanted to do for this coverage, I think yeah, I've been here about 15 minutes. Got 19 people in here, so awesome. Thank you all for being here. This is my first live stream, so may not be as exciting or as clickbait as other live streams you might be familiar with. I'm really just here for the information, give you all the full info, and yeah, and I guess have some fun along the way. So first thing I wanted to do, like I said, appellate arguments are really won and lost in the briefing. And I'm not going to read the full brief, of course. It's 100 pages long. But what I will do is just briefly go through the table of contents just to get a picture of what are the arguments that are being made to the court, because we need to understand that the arguments that are put in here, those are the only ones that are being submitted to the court. And this is important because in a case like this, high-profile case, you've got, of course, the court of law, but the court of public opinion is a very powerful thing as well that a lot of people tap into because they understand it better, which I fully understand that. But as much as the court of public opinion is used to sway public opinion, at the end of the day, if we're talking about getting a legal disposition in a court case, then yeah, it's got to be done through the court of law, which is why any argument that's not contained in this brief is an argument that we're just not going to consider because it's just not relevant for our purposes today. So briefly skimming table of contents here, statement of case, statement of appealability, just some procedural stuff, the facts, just restating the facts. Okay, one more note here I'll make too about the nature of appeals is that appeals are largely reserved for issues of law because issues of fact are decided in the trial, in the lower court, because the jury is the finder of fact. And this is something people don't quite understand. So that's why I want to take a second to just make sure we're all on the same page with it. Issues of fact are decided by a jury, and the only way that an appeals court is going to overturn an issue of fact is if they can conclusively decide that the jury was clearly erroneous in their finding. Basically, that there was no factual support for the findings of fact in the jury trial. Now, I know our feelings here. We feel like the jury verdict here was clearly erroneous because, admittedly, the facts of this case are weak. I've been over it. I'm sure if y'all are here, that means you've seen at least some of my other coverage, but we've been over it a bunch of times. Facts of this case, to me, clearly point towards a not guilty verdict. There's just clear, reasonable doubt that's just gaping holes of reasonable doubt throughout this entire case. So, however, I don't even know if, as much reasonable doubt as there is in this case, I don't even know if I would say that the jury's verdict was clearly erroneous, because clearly erroneous is about one of the highest standards possible in appeals. So all I'm trying to say here is that it's incredibly unlikely that an appeals court here is going to overturn the verdict and throw it out based on basically saying we disagree with the jury. They're going to defer to the jury hardcore and give them every benefit of the doubt in giving them their interpretation of the evidence and respecting that. So that's kind of step one here. Even though most of our coverage on this has to do with the facts specifically, the appeals court is not going to touch a jury in their finding of facts. So at least incredibly unlikely they would do so. So that leaves issues of law. And issues of law are where appeals are almost always decided. And issues of law, you're looking at the application of the law to the trial. So these are objections that were sustained that maybe should have been overruled, or objections that were overruled that should have been sustained. A judge's ruling on a motion to maybe let in some evidence or not let in other evidence. Those are just some examples of the issues of law that you're looking at with an appeal. So that's what we're looking at here. Most of this brief has to do with issues of law. So I just wanted to kind of preface that so we're all on the same page regarding that. So anyway, so some procedural stuff: statement of the case, statement of appealability, statement of facts, argument, applicable law, erroneous admission. So yeah, section 1, applicable law, erroneous admission of evidence. So we're going to have some arguments about that, saying some evidence came in that should not have come in. And B, prosecutorial misconduct. So certainly there was some allegations of that as well. We could see it in the 36 Hours Later website. Some of that was documented about basically if there was some thought that Tory might testify, but if he were to testify, then some evidence that was admitted, which here goes to our erroneous admission of evidence, the judge basically held that if he testifies, then some of his rap lyrics are going to be used against him. Some of his tattoos are going to be used against him. And this is a perfect example of something that the judge is going to have discretion over. or at least it's an issue for the judge to consider that a bad ruling on it could lead to overturning on appeal. The perfect comparison case for this is the YNW Melly double murder trial. YNW Melly, as we all know, famous for his hit song "Murder on My Mind," and everyone who's heard the song basically can hear it's almost a beat for beat retelling of someone who has murdered somebody and what that feels like and the steps that are taken. So about as much of a confession inside of a song that I think I've ever heard. But in that trial, the defense filed a motion seeking to exclude any reference to the song "Murder on My Mind," and the judge granted it because the judge did not want to unfairly prejudice the jury on something that the defense argued was artistic expression. So that's absolutely an issue that the judge can side with the defense on and exclude that stuff. In fact, I would probably argue that's something the judge should do, is exclude references to song lyrics, tattoos, stuff like that, because all these things really fall under this broad brush of artistic expression. And so the fact that the judge said he was going to let it in, and the prosecutors basically were threatening that, saying if Tory were to testify, then we're going to use this stuff against him. That could be what's being referenced here. At least that's what I think of when I see these types of things. So anyway, moving on to section 2, trial court reversibly erred in allowing testimony and evidence concerning Pete's emotions about the incident and its aftermath. So this is Pete, Megan Thee Stallion. Okay, certainly. So if the court allowed it, that means when the prosecutors were asking her questions, basically, how did you feel? How did all this make you feel? Her was really getting into the emotions of it. The defense likely objected, saying, "Judge, this is in the same sense that what I just said, talking about unfairly prejudicing the jury against the defendant. Now we're unfairly prejudicing the jury in favor of the victim that's testifying here, with just these repeated questions of like talking about Meg's mental and emotional state, which are relevant to an extent, but are they relevant to the extent that you need to be asking her every other question? How did that make you feel? And how did this make you feel?" So so it was an objection there that the judge overruled, allowed it in. That's what they're appealing, saying as an issue of law, this should not have come in. Trial court abused its discretion, overruling objections to this testimony. Alternatively, counsel rendered ineffective assistance of counsel and failing to properly object to testimony concerning Pete's emotions about the incident and its aftermath. So this is a big part too of this whole appeal. They still used it against him because they showed Tory with his tats, and the DA mentioned his gun tattoo. And yeah, that's honestly the next step of this that I'm going to need to do. I need to read through this whole brief, doing that off stream. I will do that off stream just to get the full, biggest picture possible. But what I also need to do is read through these trial transcripts and get the full picture of what actually happened in the trial. So yeah. If you're everyone, T with Tia in the comments, she is a warrior on this and many other cases. Highly recommend y'all go follow her over on X for any of your pop culture, rap culture, really anything that she covers. Does a great job doing it, and she's been a huge help, great resource for this case, for me covering it. So big shout out T with Tia. But yeah. So right here, ineffective assistance of counsel. This is a big factor that I'm looking at with this appeal as well, is because looking back at it, well, first off, I made a whole video talking about how Tory's first attorney was, if any of y'all have seen the show Reasonable Doubt, which I had seen it after covering, well, I watched the show kind of at the same time I was covering this case, and I had no clue, I had no idea that the lawyer in the show is based off a real life lawyer, and that real life lawyer was working to put the show together, and basically the whole entire show was produced by Rock Nation. So, and at the same time that she was producing this show and working hand in glove with Rock Nation, she was simultaneously representing Tory in his criminal case, where the victim is Rock Nation's star Golden Goose, Megan Thee Stallion. So clear conflict of interest. I made a whole video covering Tory's letter to the state bar. I thought that was a clear conflict, and the fact that she stayed on the case and then got out of it basically the last second, either right before the trial or during the trial. and left alternative counsel to try and step in for her. And the counsel at the trial, lawyers for Tory's lawyers, definitely dropped the ball in a few big ways. Biggest one that I noticed was the not calling Jaquan Smith to testify. The fact that he was there in the courthouse ready to testify, and the defense felt like they had enough to get their not guilty, get their acquittal, is gosh, yeah. As a defense attorney, I get there may have been some scheduling issues, and you don't want to hold the jury through the holidays. It wasn't produced by them. Don't want them to sue you. I could have swore it was, but I can look into that. But I appreciate the heads up. If I'm wrong about that, then I'll retract that. But my understanding is that there was at least close relations between Rock Nation and the show. So much so that every episode title in the show is the name of a Jay-Z song. So maybe that's just pure coincidence, but now my understanding is that there were some connections there. But if they didn't produce it, or if I'm overstating that, then I'll retract that, certainly. But regardless, so yeah, ineffective assistance of counsel, I think it was a big thing, and maybe enough to win this appeal, basically. However, here's the big factor here, and my summer I spent on the state Supreme Court where I was. We saw we just call them IAOC, ineffective assistance of counsel. Biggest thing about an IAOC claim is it follows an old Supreme Court case. Basically, you got to prove two prongs. It's that first, the assistance of counsel was objectively unreasonable and objectively deficient. That's the first part. So not just I felt like they could have done better. It's like, no, from an objective point of view, based on how a reasonable, ordinary lawyer would have done it, did they drop the ball? That's the first prong. Second prong, did it actually sway the outcome of the case? Was the person who was affected by it, would, in this case, a criminal case, would the defendant have been found not guilty but for the lawyer dropping the ball here? So that's the one thing, even though we can say, yes, absolutely, the lawyers should have called Jaquan Smith, and their failure to do so was negligent. The appeals court is going to have to also conclude that if that would have actually happened, that would have led to a not guilty verdict, and maybe that would have happened, and maybe that's what the appellate court's going to hang their hat on here. But yeah, that's just another snapshot of just one of the main things that I saw, even covering it in real time. I'm like, this seems like an IAOC claim. So yeah, okay. Part 3, the people, that being the prosecutors, engage in prosecutorial misconduct, making improper comments during closing argument. This is something that's almost certainly going to be present in any appeal, because, yeah, closing argument is the one time that a lawyer in a trial is actually allowed to argue. Actually allowed to argue the facts of the case. The entire rest of the time, they're just there to present evidence. But in closing argument, you're actually allowed to argue, make inferences, draw conclusions, pose rhetorical questions, hypotheticals, all this stuff. And there's a lot of leeway in that, so it's really hard to win an appeal over improper comments. So we'll see where that goes. But yeah, Sean Hawley impromptu exit definitely contributed to ineffective counsel, in my opinion. I'm not sure if it means much in legal capacity. Yeah, certainly. And I think that's absolutely a factor in this is going to be looking at Sean Hawley, looking at her involvement, her very undue timing for leading the case. So yeah, okay. Part 4, trial court reversibly erred in admitting evidence of Peterson's creative expression. So okay, Tia, this looks like what you were referencing. It wasn't just a threat that they would raise his lyrics and his tattoos. Looks like they actually did. Yeah, tattoos, rap lyrics, rap video, and chilled his right to testify. Evidence was unfairly prejudicial. So yeah, this is Rule 403 of the Rules of Evidence. Actually, let me just pull this up. This is I hope y'all find this stuff informative. Because I'm not just talking out my butt. I'm actually pulling the real rules here. But yeah, Rule 403, excluding relevant evidence for prejudice, confusion, waste of time, or other reasons. Basically, this rule is saying that even if evidence is relevant, it cannot be unfairly prejudicial. It has to have probative value. Probative meaning it has to be important towards like a key part of the case. Think like probing to the truth of the matter. But even if evidence is probative, if it is more prejudicial than it is probative, has to be excluded. So yeah, court may exclude relevant evidence if its probative value is substantially outweighed by danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. So that's Rule 403. It's one of the biggest rules of evidence that comes out in trial. And yeah, so anytime you see these words unfairly prejudicial, yeah, that's what it's referring to is going to be Rule 403. But I thought the appeal court already denied the Quan 1. Are you referring to the habeas corpus petitions, the attempt to introduce new evidence there, Gua Owa? Because yeah, that was the attempt to introduce new evidence was denied. That's true. But yeah, it makes me aware of how much I do not understand law or my rights. Yeah, unfortunately, kind of sucks to think about the system being so powerful, and gosh, it really can do so many things to you that you just have no clue what's even happening until it's already done with. And unfortunately, yeah, it's what makes lawyers necessary to facilitating the system. Arguably, maybe that's by design. It's a famous joke I heard first in law school, is that the reason why the law is so complicated is it's called job security, because you know who's in charge of writing laws? Lawmakers. You know what lawmakers usually are? Lawyers. So yeah, you just chalk it up to job security. We make it unnecessarily complicated so that none of you can understand it, so that way you can come and watch me explain it to you. See how it works? It's beautiful. What a beautiful business, right? But yeah, no, I fully agree though that a lot of it is way too confusing. Because here's the thing too: there's actually a constitutional grounds to have a law thrown out, and it's called void for vagueness. Basically, you can have a law thrown out if it's too vague or also just too confusing. And to me, that's so funny to think that like that's a real argument you can make to get laws deemed unconstitutional, is that they're too confusing and people can't understand it. When pretty much every law that comes out to me barely makes sense to me, and I'm trained to read this kind of stuff. So yeah, it is unfortunately just the way it works. But that's why I'm here, though. I really try and break it down as easy and simple as possible, and hopefully y'all can get some good value out of it. But all right, part 5: trial court reversibly erred in admitting inculpatory statements allegedly made by Mr. Peterson. Probably the jail call, my guess. Yeah, because inculpatory means basically admitting of guilt. So, and that was a big argument the state made. Prosecutors saying that, look, he admitted to the crime. He confessed to the crime. Meg's team loves saying that Tory confessed. When we've all heard the video. We've all seen it. It's just not what happened. But court reversibly erred in admitting an allegedly inculpatory Instagram post, which is disclosed to the defense in an untimely fashion, amounted to inadmissible hearsay, was highly prejudicial, thereby resulting in manifest injustice. It's referring to the Instagram post where someone was saying Kelsey did it, and then Tory's account commented and said, no, she didn't, basically. And that was attributed to Tory. My understanding, the explanation was that it was somebody else who had access to his account that made that post. Regardless, though, even if it was by Tory, if it was disclosed to the defense, basically like, say, the day of trial, then yeah, that could be a discovery violation. Discovery, basically, we really try and avoid the court trials. Trying to avoid trial by ambush. That's the key term here. We don't want to have trial by ambush, and so the way you get around that is by disclosing through the discovery process. You disclose basically the entire case ahead of time, so that both sides know where the other's coming from, and both sides can be fully prepared for the trial itself. So that way you don't have to waste time in trial figuring stuff out that should have been figured out beforehand, because that's what judges hate more than anything. So yeah, defense untimely fashion. If you don't disclose stuff in a timely fashion ahead of time, then it should not come into evidence. So, and yeah, especially, once again, Rule 403, even if it is probative, it's highly prejudicial, should be excluded. So, admitted violation of statutory notice requirement. Instagram post amounts to inadmissible and inherently unreliable hearsay, that exception. Yep, so all just about the Instagram post. Trial court reversibly erred in admitting Harris's recorded statement to prosecutors. And this is a big one. This is one I've already identified through my coverage as being a huge boo-boo by the prosecutors and just a big hole throughout the whole process. So before I get into that, catch up on these comments, So they denied Kelsey's driver's statement. So yeah, that was crap. It's been a while since Bradley James, was it? Yeah. Yeah, so that was something that's come out recently. I don't know if that was included in the habeas petition, but I can see why they would want. Basically, yeah, in the absence of like hard forensic evidence, an appeals court is unlikely to allow new evidence to come in. Because as much as I believe Bradley James, I believe he overheard Kelsey's statement where she admitted to being the one that shot Meg. I fully believe that. I think that his statement is reliable. And it's very relevant to our analysis of this case. However, what's to say, and I'm not saying that's what happened here, but what's to say he was completely making it up. He was bought and paid for to basically lie, even signed to an affidavit, but he was doing so falsely, fraudulently, just to try and create some sort of evidence to then use in an appeal. Like I said, I don't think that happened here. I think he's telling the truth here, but basically, that possibility is the reason why an appeals court is not gonna let in basically these types of statements into their appellate analysis. If there was like DNA evidence or like, that's another big part of this case that done a lot of coverage about. But for purposes of this appeal, yeah, they're not gonna let that statement in. So yeah, they denied that coming in. Doing great work, counsel. Thank you, Jay Muzak. Much appreciated. Justin Edison allegedly saying Tory admitted it. I'm not familiar with that claim. If you don't mind, I guess, enlightening me, Justin, who is Justin Edison? Give me a little more details on that. Here's the thing, too. As much as I like to be as informed as possible on this case, yeah, just with life going on and all the craziness, y'all actually, I would argue, even though I've got a lot of knowledge, I think y'all collectively have more knowledge about this case than me, about the facts of the case. That's why I've loved making these videos and hearing y'all or seeing y'all down in the comments, because every time I uploaded, I learned something new down in the comments. Usually I learn a few new things, even in this live stream. Yeah, Simply Fee, you're corrected me on the Rock Nation Reasonable Doubt stuff. So I hope y'all never think I'm like the gospel that has all the information. When I do have the information, I like to think my analysis is pretty sound, pretty solid. But yeah, that's always the journey, is trying to get it all. But just trying to be honest, trying to be transparent with y'all. But anyway, 3:33 in Toronto. Congratulations on that. Cool stuff. I mean, 3:37 now. Sorry. This live streaming thing, it's interesting because I'm trying to like keep going through this, but I'm trying to stay up with y'all in the comments. Yeah, George, all right. Tory's first trial attorney. Yep. I thought they denied it because it wasn't submitted timely. Bradley's statement. Simply Fee. All right, the habeas wasn't denied in the merits. It was on technicality. They said Tory's lawyer knew that Quan was going to say at trial. They said Bradley's statement should have been submitted sooner. Okay. Yeah, I'll have to read that. I'll have to read that more closely to see why. Because all I saw was the kind of the headlines that it was denied. I did not have time to get into reading that. But Megan's bodyguard. Oh, okay. So Justin Edison, Megan's bodyguard. Did Justin Edison testify? I don't know. Anyway, okay. All right. Sorry. Last couple things. Overview here. Oh yes. So this one, reverse by error admitting her statements to the prosecutors. This is a big boo-boo because her statement to the prosecutors, she basically corroborated 1-to-1 exactly what Meg's story was, and yeah, it's under that pretense, when you've got 3 people there, we've got 4 people there, but Jaquan Smith didn't testify. So of the 3 people that were there to testify, you got Meg saying Tory did it, and you got Kelsey saying Tory did it. But Kelsey only ever said that during the pre-trial interview. So what happened at trial? She gets up, she takes a stand, and she recants everything she said during that interview. She no longer testifies that Tory did it. She says she either doesn't recall or that everything she did say, she lied to protect herself. So, complete bombshell testimony in court. However, what did the prosecutors do in response to that? They moved to get her prior statement admitted into evidence. When you got her here on stand under oath, testifying, saying he didn't do it, and that she lied in that statement, the judge should have absolutely excluded that statement. Now, was that exclusion, is that enough of an error to overthrow this verdict? Maybe. But I keep saying maybe because I don't know if any one of these things by itself is going to be enough, and I don't know what the appeals court, what they're focusing on more than other things. But that's a big one. In my book, that is a big one there, is the admission of her recorded statement because her in-court statement, the prosecutors didn't like it. So, okay. Prosecutor testified for Justin. I see. Okay. Yeah, that shouldn't have happened either. So maybe that's part of the closing argument, improper comments by the prosecutors that we'll get to. But no, he didn't. But you see, the prosecutor said that he would. Okay. That she said she lied about at trial shouldn't have been allowed. Yes, she's a key person. Yep. All right. Trial court reversibly erred when instructing the jury. There's almost always going to be something you can take issue with based on how the judge instructs the jury. Looks like we actually got 12 pages from 74 to 86 about that. So quite a few. People engaged prosecutorial misconduct, which interfered with Peterson's right to conflict-free counsel. Okay, sentencing court reversibly erred in declining to impose the lowest possible term. Cumulative effect of these errors warrants reversal. Boom. Okay. Well, my quick overview of the table of contents alone went for about 30 minutes. So appreciate y'all sticking with me. But all right. So with that in mind, we've got a snapshot of some of the arguments that we might get from this video. So, without further ado, I say, let's jump in and see what we got.
Morgan Legal Services.
And right there. Immediately hit by an ad. Imagine that. Alright, first upgrade I'm making, getting a better microphone. Second upgrade I'm making, YouTube Premium, so y'all don't have to watch these ads. But alright.
May it please the court, my name is Crystal Morgan.
Hold up, let me fix this. Alright, no music for this since it's kind of quiet. Sorry, I got it turned up to max. Let me turn it up over here. Okay, this should be good. Let's see.
With Unite the People, Inc. and the Baez Law Firm for Mr. Daystar Peterson, who is the appellant and the defendant. We wish to begin by acknowledging the harm expressed in this case. For those that were affected, our arguments today are presented with the unwavering belief that our client, Mr. Peterson, is innocent, with the utmost respect. It's important as we would like to clarify that any display of empathy should not be considered an admission of guilt. That guilt is established in the bedrock of our criminal procedure that is from the prosecution. And in this case, that was...
Yeah, let's always keep in mind the burden here is guilty beyond a reasonable doubt. And it's a very, very high burden for the state to meet. And it's good, I think, a good place to start. I mean, so it's partially redundant as far as, these judges, they know that. But as far as, you want to kind of lead off with your big picture overview, hey, here's what we're dealing with. And I think that's a good place to start. As far as the judges panel here, I don't know if there's supposed to be a fifth judge. Maybe they're maybe like a Zoom call, zooming in. I know some courts are able to do that, but my imagination says that, yeah, there should be 5 hearing it, because what if it's a 2-2 split? So, yeah, my guess is that there's going to be the fifth. The fifth is involved in some way, even if it's going to be maybe by just listening back to the recording. But yeah, panel of 5 judges, they'll be hearing it, and they'll vote basically after hearing the arguments and reviewing the briefs. They won't vote at the end of this video. We got to wait for that. They go back in chambers, they'll debate the case with each other, and then they'll vote either to overturn it, not overturn it, remand it with new instructions. There's a lot of different things an appeals court can do in response to an appeal. But yeah, we're not going to get any answer anytime soon, really. But
riddled with numerous errors. That standard was not met. We believe the most compelling arguments are the testimony of Ms. Kelsey Harris when looking at the confrontation clause, prosecutorial comments in the opening and closing statements.
Okay, sorry, before we get too far away from that, and actually I'm going to speed this up because I know, y'all know me, I'm a yapper, and I like to get in depth, but what you just said there about Kelsey and the confrontation clause. So the confrontation clause is part of the 6th Amendment, It's a constitutional right to anyone who is accused has a right to confront their accuser. And if y'all can think about what happened at the trial, if the prosecutors is going to rely on Kelsey's testimony in proving their case, well, then Tory has a right to cross-examine, to confront Kelsey as a witness and cross-examine her testimony. The only problem was he had no ability to cross-examine her on the stand because she wasn't giving anything on the stand. She kept pleading the fifth, saying she didn't recall or I plead the fifth. Well, he can't. Every question he asked her, she pled the fifth. So there was no ability to cross-examine her. So what did the state have to rely on? They had to rely on the recorded interview she gave to the prosecutors. Well, guess who was not present for that recorded interview? Tory or his attorneys. So he had no ability, him or his legal team had no ability to cross-examine her answers during that interview. So it was basically the state got to just use a one-sided, one-sided telling of a story that she recanted in open court. So yeah, the confrontation clause is a huge, huge deal, and I think it's a great place to start for purposes of this appeal.
And Brady violations that cumulatively occur. Prosecutorial comment testimony of Ms. Kelsey Harris when looking at the confrontation clause.
Yep.
Prosecutorial comments in the opening and closing statements, and Brady violations that cumulatively occurred throughout the trial.
And Brady is another big buzzword when it comes to the law, because Brady is referenced to a Supreme Court case called Brady versus Maryland. Brady is basically the ethical obligation by prosecutors to disclose any exculpatory evidence that they might have that might prove the defendant's innocence. If they have it, because the state is the one tasked with investigating the case, right? They're the one that gathers all the facts and they bring it to the court. Well, what if through the investigation, the state comes across facts that proves the defendant was not the one who committed the crime or was not even present at the crime? Then if that's the case, then the state, they have an obligation, ethical obligation to disclose that to the defense. So violating that's violating Brady, and that is absolutely grounds to have a case thrown out if true. But hold up, I see a little debate we got going on down here. Jay, the burden of proof is on the state, not Tory. Correct. I think, Jay, are you saying that as in this case it was on Tory, and that was wrong? Because the burden of proof is on the state to prove the case. Also fail the burden of persuasion. Yeah, the burden of proof is on the state to prove the case. I think I think I've said this before here is that it feels like in this case the burden of proof was on Tory to prove he did not do it, which I think absolutely feels like what happened here. But so okay, yeah, I see. I got you, Jay. I didn't think you're one of my homies. You've been here all stream so far. You're rocking with me. I'm rocking with you. I figured you were saying that as that's what felt like happened here, but yeah, no, I got you, my guy. Okay.
To start with the confrontation clause, particularly with Ms. Harris, who was present in court and also present on the night in question with Mr. Peterson, Ms. Pete, and Mr. Smith on July 12th, 2020. Ms. Harris gave testimony on December 14th and 15th. These dates are important to note, but she only gave that testimony after asserting her Fifth Amendment rights. With the confrontation clause, what we must do is a very fact-specific analysis, and we must weigh Ms. Harris's right to not self-incriminate with Mr. Peterson's right under the Sixth Amendment to confront those witnesses. Because of this, we have to analyze this and take it step by step. So the first step is seeing if we have a testimonial statement. And this is according to Crawford v. Washington, 2004.
Yeah, Crawford v. Washington. I was trying to think of the case earlier, but I don't want to misspeak. But Crawford v. Washington, that's the seminal confrontation clause case. My summer on the state Supreme Court, every IAOC, different thing. No, every confrontation case we got, referenced Crawford versus Washington, because that is the big case. It gives the two-part test that she's about to go through here. So Jay Mezak, smash the like button. I agree with Jay. Everyone, if you're in here and you're enjoying the stream, smash that like button. Really appreciate it. I really just appreciate your time that y'all are here, and y'all make this worth it just to cover cases like this. But But if you want to take it that little step further, then yeah, go down and smash that like button, and yeah, just continue enjoying the show. But yeah, okay. So step 1, confrontation clause. Was there a testimonial statement?
541 U.S. 36. These statements were further defined whether to be testimonial or non-testimonial by the High Court in Davis v. Indiana, which is found at 547 U.S. 813. And
so real quick, testimonial statements versus non-testimonial, what she's mentioned, and she may be about to explain this, so I might be getting ahead of her. And yeah, also, I have not watched this video yet. This is my first time watching it, so I've not pre-watched it or anything. I've skimmed over the brief before, just a little bit, but I don't know exactly where she's going with her argument, so I might say something that she's about to say anyway. But testimonial versus non-testimonial. Basically, a testimonial statement is a statement that's gathered or obtained before the trial for the purpose of being used at the trial. So versus a non-testimonial is a statement that might be gathered just kind of naturally through the course of an investigation, or just naturally through like an active ongoing emergency. So the perfect example, like cases that you'll read about this kind of stuff, is someone calls 911, police respond, they say, oh my gosh, there's a bank robbery over there, and I saw the guy run, and he was wearing a red shirt. And the police will go and they'll run around the corner and they'll go tackle a guy with a red shirt. And he gets charged with bank robbery, and the state will try and use that statement of the identification. It was a guy with a red shirt, and the question is that testimonial? Well, because it was an active emergency situation, it was just trying to settle the emergency. That statement is non-testimonial, because when that person made that statement to the police, they were not intending for that to be used in court. So that's an example of a non-testimonial. But when you're going into the police station or the DA's office and you're sitting down with the prosecutors and for a recorded interview, that is absolutely testimonial. Every statement she made there was testimonial that Kelsey made. And so the fact that, that was allowed to come in it still just boggles my mind. But yeah, it's absolutely testimonial, and I think fulfills this first prong of the confrontation clause analysis.
2006. Statements are testimonial when the emergency no longer arises, when the statement is being given in response to a future prosecutorial event. So we know that Ms. Harris, when she gave her interview with the district attorney's office, was giving a testimonial statement.
Yep.
Therefore, the first prong is met. But the second prong is not so easy to establish. We need to determine if Ms. Harris was available or unavailable, which is a little tricky in this case, which is why we need to walk through each step. So
it is tricky because she was physically available, but she was pleading the fifth, so you weren't getting any information out of her. And I believe my understanding, there is case law that says when someone takes the stand and they plead the fifth to everything, that can be determined to be unavailable. Even though they're physically available, they are unavailable for purposes of testimony. So that's another big part of this analysis here.
Ms. Harris walked into court and said, I exercise my Fifth Amendment right. That made her unavailable. But when they granted her use immunity, she was thereby available again. Yet she still got on the stand and testified in a manner that was not consistent. She said, I don't remember. Or she said, I was dishonest in my interview with the district attorney's office. Therefore, because of the way she was testifying, they decided at first to take this interview, which at the time we did not have a transcript for. And they were playing portions of the recorded statement to refresh her memory that the jury heard.
So this is another, oh gosh, I didn't even realize this was happening. But now that I think about it, it makes sense that it was, because if you've got a witness who takes a stand and they say, I don't remember, well, what you can do is what's called refresh the recollection. And if they have a prior statement they made or something that they did, or maybe a statement in a police report, like usually what we would do in court, if I had an officer on the stand back when I was a prosecutor, I have an officer that's on the stand, and maybe they said something that I knew they observed. So, for example, drunk driving, DUI. And I know in their report they marked down that this person had red glassy eyes. And I'm asking them, I asked the officer, what did you observe that night? And he gives all these things that he observed, but he forgets to say red glassy eyes. And I say, did you observe anything else? And he's like, no, I think that was it. I could use that opportunity to say, Your Honor, or could I, no, actually, I'd ask the officer first. Would reviewing your report you took that night, refresh your recollection. He would say yes, and I say, Your Honor, may I approach? I would approach the witness, give him his police report, and he could read through it, refresh his recollection, and see, oh yeah, also I saw that he had red glassy eyes. So when you have, as a prosecutor, that's one of the tricks that you've got. When you've got a witness here, Kelsey, who's on the stand, who's pleading the fifth, well, I guess not even pleading the fifth at this moment, she's saying she doesn't remember, she doesn't recall, then yes, I can see the prosecutor is using her prior statement to try and refresh her recollection. However, if y'all can see the difference between the example I just gave versus the example here, the example I gave just has an officer silently reading a piece of paper and has no effect, no impact on the finder of fact, which in my case was a judge. It was a bench trial. Here we've got a jury. Where the rules of evidence are so particular to try and narrow down exactly what a jury is and is not allowed to hear. It's so particular because that's so important, because you have no idea what might sway a jury into an unjust conclusion. So the rules of evidence are very, very particular on this. And when you've got this statement that's just being played, there's huge parts of it, and playing it to her in open court, and the jury can hear it. They're hearing every part of the statement. And the statement has not been admitted as evidence either. The statement is just being used to refresh recollection, so it doesn't need to be admitted as an exhibit. And the jury's hearing this. It's like, to me, this is so prejudicial to the proceeding that you've got a witness who's basically refusing to testify, and so you're playing a video that's testifying for her. Now, granted, we know where this ends up in the end, which is that the whole video ended up just coming in anyway, which I still think is just obscenely and insanely prejudicial. But regardless, yeah, I think this is a great starting point for this appeal. This is one of the stronger, if not the strongest, arguments regarding I think the issues of law that can absolutely be grounds for overturning this case on an appeal.
So at first, that was going on in her direct. Then in her cross-examination, as she continued to testify in this varying manner that wasn't the way everyone expected her to testify, they entered the entire recording into evidence. Mm-hmm. But that recording was not entered into evidence while Ms. Harris was giving her testimony. It was entered into evidence on December 16th. And at that point, this is when the defense received that transcript, which we argue not receiving that transcript was a violation of Brady, and it also was a violation of Penal Code 1054.7, Your Honors.
So the penal code she just referenced, I don't know what that is. There might be something to that. Brady, I'm not as convinced there. I mean, y'all know me. I'm honest as can be, transparent. And when stuff is not as compelling to me, not as convincing, I'm going to say that. Because I want us to focus on the arguments that are the most convincing. Is it a Brady violation to have not turned over the transcript of that interview until the day it was admitted into evidence? I can certainly see as a defense team, that sucks. Like, that just feels so bad because you're like, the fact that this video even came in the first place, that's my main issue here. But Brady has to do with the intentional withholding of evidence that is exculpatory of the defendant, or more generally just discovery violations. I think the big wrench in this plan here, or this argument here, is the fact that I don't think the state was intending to do this here. I think the state was intending that Kelsey would just take the stand and testify and say exactly what she said during her interview. So they wouldn't even need to use the interview because she would testify and say the same thing under oath on stand. So, but here's the thing about trials. Trials are all about adjusting on the fly. And when you have a witness who all of a sudden becomes uncooperative, that's a curveball and you just have to adjust. And so I think the state, basically they just had to roll with the punch there. They were not expecting Kelsey to go plead the fifth on everything. And so at that point, they're like, well, we still want to get the statement in. So they did what they did with the video. And then when that happened, that's when they disclosed the transcript to the defense. So I don't see that as a Brady violation per se. But maybe very well could be under the state penal code. But I thought Brady could be intentional or accidental. Yes, that's true. It could be. But when we're talking about accidental, that's more falling under the grounds of maybe you got lost in the shuffle, you didn't know that you had this evidence, and then when you found it and then you disclosed it and it was too late, it's like, well, yeah, it was technically accidental, but that could still be enough grounds for a Brady violation. My thing here is the fact that it was basically, this whole sequence happened as a result of a sharp left turn, a curveball that nobody was expecting. The state was not expecting Kelsey to plead the fifth like that. Tory's team was not expecting her to plead the fifth like that. So because it was like a very dramatic just turn in what was happening at trial, I think the court was willing to grant a little bit of leeway as far as still allowing the state to present its case, which I think to the extent that the whole video was allowed in, I think that's, still, like, I've been clear on that. I think that's a violation, absolutely. But when it comes to the disclosing of the transcript, I think that's kind of wrapped in with the video. If the appeals court finds that the video should not have come in, then yes, the transcript getting disclosed is also, that also is grounds to throw everything out. But if the appeals court finds that, well, trials are fluid and flexible and things kind of go sideways all the time, so we're not going to overturn the judge's discretion here to allow this in. Yeah.
Hi, everyone. Mark Barden here.
Sorry, y'all. Like I said, YouTube Premium is coming up next.
So we have this now statement in evidence, which is a transcript of a testimonial statement given to the prosecutors. In order to get this into evidence, they have first argued that they were going to use it to impeach Ms. Harris. This is because in their opening statements, the prosecutor said that Ms. Harris was going to testify that Mr. Peterson had violently pulled her by her hair from the car. This is a fact that was not proven at trial. Ms. Harris did not testify to this. Therefore, we feel that also is one of the inappropriate opening arguments. But additionally...
And just a quick note on that. Sorry, I always make it a quick note, but got for 5 minutes in, and it's been like 20 minutes watching it. But let me move myself too so we can see our lovely counsel here. Yeah, the big issue that appeals courts have with erroneous opening statements is that, once again, kind of like I just mentioned, trials are fluid and flexible, and things go sideways all the time. And yeah, all the time lawyers will say something in opening that they fully plan on proving, and at the time, that could be a reasonable belief. Like, yeah, at the time, the prosecutors reasonably thought Kelsey was going to testify to what they expected her to testify to. So if for them to then say in the opening statement that, yes, to say in the opening statement basically what Kelsey said in the interview, I don't think that's erroneous. I think that was a reasonable assumption for the prosecutors to make, and then it only became this crazy, like, oh, they said this crazy thing, and then they never proved it. It's like, well, yeah, that's because their witness kind of threw everybody a curveball. So it's tough with statements like that. But I guess the test here is going to be, was it reasonable for the prosecutors to have made that statement? Was their belief reasonable? Because if the prosecutors promise something that they fully do not intend on proving, or they know they don't have the evidence to prove it, but they say it anyway, and it's something like this where it's like, you're going to hear that Tory pulled Kelsey out of the car with her hair, by her hair. And it's like, yeah, that's something that's really influencing the way the jury sees the defendant. So, yeah. Okay.
To that, we strongly objected to the late discovery of this transcript. And it wasn't just the late transcript. There were numerous other instances that the trial attorney did object to. But nonetheless, ultimately, the court did admit this statement under both Evidence Code 1235 and Substantive Evidence Code 770. So now it's in, and we have a very unique situation here where we have a testimonial statement. We have a witness that doesn't want to give us answers and is saying, I was mistruthful in my interview only in September of 2022. And this trial was in December of 2022. So it's clear that she did not want to cooperate. She said as much on the stand, I don't want to be here today. As a result, these matters, we feel that we need to look at the reliability and the prejudice to Mr. Peterson. And as Ms. Harris stated, I didn't tell the truth. So we can't rely on these statements from her own words.
True.
And this did greatly prejudice Mr. Peterson, because in that interview, Ms. Harris said, my friend and I were attacked and it was this man's fault.
Yep.
And then at trial, she did not verify those statements, but the jury still heard those statements nonetheless. And we know that the jury relied on these statements because during deliberations, they did ask for a copy of that transcript to further analyze it. Therefore, we feel that the totality of this circumstance really does show that Mr. Peterson didn't have a chance to confront that witness in the.
And yeah, that's a big fact as well, that the jury requested, because juries, they can ask a question during their deliberations, or if they want to see a piece of evidence again, to go over it more with a fine-tooth comb. For them to come out and say, yeah, hey, we want a copy of this transcript from this interview so we can more closely look at it. Then they're really looking at it very closely, very in depth. So yeah, it's man, for that to come out, for them to want the transcript, gosh, yeah, I still just cannot believe that came in. The video came in, and this lawyer, great job. Yeah, I mean, 7 minutes in, she spent the entire time so far talking about this one issue, and I think, more power to her. This is the strongest argument that she's got for this appeal. But all right, but the defense should immediately have been informed Kelsey did a testimonial video, though right not when prosecutors needed to use it in court. Yeah, I think. I mean, but here's the thing, though: the determination of whether or not the video is testimonial, that's not necessarily something that's relevant until the time of court. Because here's the thing: as a investigatory agency, prosecutors, police, detectives, they're taking interviews of everybody. They're not basically nonstop. Especially a big case like this, you're going to be interviewing everybody. So the fact that they interviewed is not a surprise. But I agree. The fact that we had this big twist in the trial, and now this video became as big as it became, then that feels really bad as a defense team tasked with protecting against constitutional violations. And now all of a sudden you've got basically new evidence that's being thrown at you during the trial. And so I don't fault them for making the argument. I just don't know if the court's going to grant it on those grounds specifically, that it was a Brady violation.
Sixth Amendment context. Additional errors occurred throughout opening and closing statements. Start with the opening statements. We heard the prosecutor promise that he was going to put Mr. Justin Edison on the stand, and that Mr. Edison would say that the following day, when Mr. Peterson met with him to give Miss Pete and Miss Harris's belongings to him, that Mr. Peterson confessed that he did this crime. So the jury in opening statements at their first introduction to Mr. Peterson heard, he's guilty. And he said so, and I'm going to put a witness on the stand to prove it. But Mr. Edison never testified in the trial.
So that's okay. That's kind of the big one there. So appreciate all the background we got earlier on Justin Edison, but because that's a whammy too. Kind of what I was saying earlier about, the world where I can see how an opening statement is going to be improper is if you make a statement knowing that you're either not going to prove it or you cannot prove it, and now here we have argument here that in the opening statement the prosecutors said Justin Edison is going to testify and he's going to say this, that, and the third, and you never call him. And now y'all can correct me if I'm wrong. I'm assuming he was available for the trial and that they could have called him if they wanted to, because some other people were just simply not available. But my understanding is Justin Edison, he was there, he was available for the trial. So the fact that the state did not call him, this absolutely comes down to me as an improper opening statement. If you're going to reference anything in your opening, you better be ready to prove it during the trial. But okay, here's the other thing too. I forgot to mention at the beginning about appeals. And gosh, 54 people in here. I'm really happy, really thankful for that. I mean, like I said kind of earlier, I was expecting maybe like 2 or 3, maybe like 5, hopefully even 10, but 54 of y'all in here. This is awesome. And it's good. It's for a good cause. Like, this is a really important case that I know we all care about a whole lot. So, so, okay, Justin didn't want to testify. He went missing. Okay. So, actually, no, I think I remember reading that, is that I remember there was a bodyguard that went missing. I thought that was always reference to Jaquan Smith, but then as I read more into it, I realized no, Jaquan Smith was there in the courthouse. It was Justin that was not available. So, okay, Justin didn't want to testify. He went missing. Justin was trying to avoid testifying. They had to issue a body attachment for him. He was not available. Justin's family went on the news about being harassed and want to be left alone. Jeez, okay. So then this actually does change my analysis too. The question here is going to be, did the prosecutors know Justin Edison was not available? If they knew he was not available, yet they said in their opening statement, he's going to testify and he's going to tell you that Tory confessed, absolutely. Huge error, very prejudicial. That by itself could be enough to overturn and to get it thrown out. So if they knew that, that's big. That's huge. If they did not know he was unavailable, or if they thought he was available and they say that, I don't think this is an issue. But KG is saying they knew he wasn't available. Then if that's true, that's a big point, because now that's going squarely into what I said earlier before even knowing what was about to be argued. I said that exactly earlier. If the opening statement, you say something you know you can't prove, that is absolutely prejudicial. But this brings me to the point I was going to try and get into, was the other standard here when it comes to appeals is this idea of error and whether or not an error is harmless or not. Because basically, we can do all this analysis and we can conclude that, yes, absolutely, errors were made. But if it comes down to the end of it and the court finds that, yes, even though there were errors made, the errors were harmless in the sense that it didn't really affect the outcome that much, they can still uphold a conviction based on that idea of a harmless error. So, of course, I think we all think, these are not harmless errors that are happening here. But I just want to keep that in mind for everybody, too, that even though we're pointing out error after error after error, the court has to be convinced that these are not simply harmless errors. These are real, substantial errors that significantly impacted the case. But let me see. Justice for this young man. Free Tory. There was an injustice done there. Umbrella's court system is RD. That means they rigged? I don't know. He went overseas for a job. They legit had to track him down. Wow. He was subpoenaed. He showed up the last day. You're a true one. You a true real one at Oh Right. Yeah, Oh Right. You holding it down in the comments too. I got some real warriors in here. So yeah, y'all are seeing some legendary warriors on this case in this comment section. So anyway, let's keep going.
Mr. Edison was not being cooperative with the prosecutors. In fact, in November 28th, 2022,
I ordered 200 hand-forged knives to my dorm room and built a Wix website to sell them.
The court had to put a body attachment onto Mr. Edison. And on December 5th of 2022, Mr. Medesian, our trial attorney, actually filed a motion in limine specifically for this. And he stated that he was very concerned that Mr. Edison not coming to court would severely prejudice Mr. Peterson, and he urged the court to not allow such statements in opening. This motion was not granted, and so the court heard that Mr. Edison was going to testify. When Mr. Edison didn't show up due to media coverage and comments made in the trial, it was implied that Mr. Peterson was responsible for Mr. Edison not being in court with no proof of such contentions, which further prejudiced the jury. The body attachment continued at that point, and he still did not cooperate with the prosecution. We know in California, due to Hawk v. Superior Court, which is found at 42 Cal App 3D 108 in 1974, this is the controlling case that supports the contention that opening statements are confined to a reasonable good belief of what the prosecutor feels he will be able to show in the trial.
And good. There's some case law basically restating what I said earlier about, opening statements. Yeah, if you say something that's technically improper, but it's under a reasonable belief that it was proper, then it's going to be fine. They're not going to overturn on that. Also, hello, Lyrax. Good to see you in the chat. Totally not my sister speaking. I appreciate that. Yeah, FYI, that's my sister, everybody. Everybody, say hello to everybody by you. yeah, she streams on her own right, and so that part of the inspiration for me to give this whole streaming thing a shot. But also, she knows nothing about the Tory Lanez case, so she's probably super lost right now. But that's okay, because we are here, warriors for justice. She's incognito. Here, put a couple umbrellas in the chat, and that'll, yeah, one of us.
Reasonable good faith, arguably, very respectfully, is not having a body attachment on a witness. The witness may or may not be trying to avoid the process. We don't know. He's just not there. And so that's all we can rely on. And ultimately, what happened is exactly what Mr. Medesian was afraid of in his motion in limine. And what Hawk warns about is that we must have this reasonable good belief in these opening statements to promise something, especially when it comes to a confession, because the jury is going to believe the prosecutor. They're going to rely on those words and have the prosecutor guide them and direct them to show why Mr. Peterson was guilty. So because of the great weight that the jury naturally gives the prosecution, we feel that these statements were inapposite to a good faith belief. Generally, a court would give a limiting instruction and attempt to cure such a situation. But in Mr. Peterson's court, no such instruction was given. There was no curative instruction for.
That's another big thing about when things go wrong in court. One of the best things that the trial court judge has available are, what's called limiting instructions, where basically they're acknowledging that maybe this might be wrong, and because of that, I'm going to instruct the jury, basically say, look, this piece of evidence is coming in, but you are not to use this piece of evidence for as a substantive piece of evidence. Maybe it's just for impeachment purposes or something else. So sometimes limiting instructions, they're really kind of just a formality, and everyone knows, okay, this video, say the Kelsey Harris video comes into this trial, but the judge is like, but it's okay, I'll fix the error by giving a limiting instruction saying to the jury, your only purpose for watching this video is to hold it against Kelsey and impeach her character and credibility. That's the only reason that you are to watch this video. Okay, that might be the reason that the judge is letting it in, but you think the jury is going to watch that video and only use it to impeach Kelsey's credibility? Or are they going to use it to look and see, oh wow, this is her testimony about what happened that night? So yeah, sometimes limiting instructions really do not do anything, but in the eyes of the law, that's like I keep saying, I led this whole stream off by saying we're talking about the court of law right here, not the court of public opinion. In the court of law, that's where we are right now. We're trying to argue to these judges, and they're going to be very interested in whether or not limiting instructions were given, because that's kind of like the band-aid you put over the problem in court. And if a limiting instruction is given, then the judges are going to look favorably upon that and likely not overrule or not overthrow kind of what happened in the trial court. But the fact here that a limiting instruction was not given, that's good. That's another good argument, another big piece of information that goes towards helping Tory. But yeah, okay, I see y'all are making friends down there. Yeah, I need some mods. We got some crazies in here. Yeah, Lyrax. I need to... I feel it's weird calling you Lyrax, though. Can I just call you Blue? That's her Twitch name. I am Royal Blue. Yeah, there you go. Free shout out. Yeah. But Tia, what you think about the DA not having proof that they ever spoke to him? I'm assuming you're talking about Justin Edison. So you're saying that the DA did not have proof that they had ever spoken with Justin Edison, yet they were arguing that we're gonna call Justin Edison, and he's gonna say all these things. He's gonna say that Tory confessed to him. Yeah, no, if that's true, yeah, I mean, gosh, it just stacks up. Just thing after thing in this case just continues to stack up and pile up of how bonkers. Yeah, crazy, man.
These opening arguments. And people.
So let me ask a question here. So are you arguing that any time a witness is subject to a body attachment, that any reference to that witness should be off limits in opening statement?
I think that the prosecutor should be extra careful in such a situation.
Yeah.
Because they're going into this knowing that that witness is not cooperative. So I think that if they say that they hope to produce such a witness, that perhaps would be enough. But here there was just no hesitation. And I think it's especially true in the case of the evidence that we're dealing with Mr. Peterson, that it was a confession.
And so what was the evidence or indication that the people did not have a reasonable good faith belief that they would be able to produce Mr. Edison at trial?
We actually have no proof of the district attorneys ever speaking to Mr. Edison. The defense was never provided of a copy of any interview that they conducted on this witness. We have no physical evidence. All we have is an email from the district attorney in this case that said, I didn't disclose this and I meant to disclose it, but we are going to call this witness who will say that Mr. Peterson confessed to him. So I honestly, despite my best investigations, we cannot find where this statement came from. We cannot ascertain the veracity of these statements. That's why I think it's inappropriate. I don't think it's always inappropriate, but in this case, with these particular facts, I do feel that it's inappropriate. And
yeah, no, I think she's on the money. Now, I will say, just kind of based on that, certainly it's compelling. It's a compelling argument to make, saying that there is no evidence that this ever happened. There is no evidence that the state ever had contact with the defense, or with this witness. Now, the only caveat, it's a small caveat, small asterisk I'll throw on that, is saying just because the defense doesn't know, or the defense is not aware of any evidence of their communication, does not mean there is no evidence of said communication. Ideally, yes, it would have been made public, made available, so that everyone can know about it. That's part of the issue here, is that there was stuff that was not being made available. But I struggle to conclude that. Yeah, I struggle to conclude thinking that the state just truly had zero contact whatsoever with this witness, yet decided to, they had never even spoken to the guy, yet they were planning on having him testify. Like, I have to imagine there was at least some sort, even if it was marginal, even if it was nominal contact, that there was at least some level of communication there, and some understanding that he was going to be expected to testify. So maybe there is some communication. Is it to the extent that should prove reliable to a DA in thinking, oh yeah, I can definitely call this witness and they're going to be reliable, they're going to show up? Probably not. Sounds like it was not here, but I have to imagine there was at least a little bit of communication.
There was also problems in closing arguments, which contained inaccuracies, and it presented the evidence in a way that misconstrued the actual results.
There's a lot more of a strict look at statements made during closing arguments, because now you're at the end of the case, you're at the end of the trial, all the evidence has been received, all the exhibits have been received, all the facts have been heard, and now it's your time to argue about what's been presented. So the biggest way lawyers trip up is that they argue things, they do what's called arguing facts not in evidence, where they'll make some sort of argument, maybe based on an exhibit that was excluded. It never came into evidence, but they referenced it anyway. That's improper. But yeah, you have to know. So on the one hand, while you do look a lot more strictly at closing arguments, on the other hand, the lawyers do have a lot of leeway, a lot of discretion, or latitude, I'll say, in making their closing arguments, because this is the one time the whole case you're actually allowed to argue the case and argue the points of facts and law, because you're not really allowed to do that throughout the rest of the case. So on the one hand, yeah, you look more closely at closings. On the other hand, you don't. So yeah, we'll see. I'm very curious what statements were made.
Here, I'm specifically talking about the DNA evidence. So we heard the prosecutor close the case by telling the jury, don't be fooled when we hear that Mr. Peterson is excluded. But that's not exactly what the evidence said, which they had in their possession. I feel that statement really misled the jury. It may have confused them. It played on their emotions. And we know that that's not appropriate in closing statements. And in order to really understand the weight of that statement in closing, we need to understand what the evidence was that the district attorney had available to them. So as shown in our reply brief, as for the magazine, there were 4 DNA profiles discovered on the magazine, none of which that were Mr. Peterson. Therefore, he was excluded from the magazine. As far as the firearm goes, they also found 4 different samples, one of which was a 90% male contributor. But Mr. Peterson was excluded from being that 90% contributor. Therefore, telling the jury, don't be fooled when you hear he's excluded, is just not quite as the evidence showed. And
yeah, I certainly think, as a point of law, I still think it is the compelling argument to say that, yeah, the DNA evidence is strong. It's strong for Tory in proving that he was not the one that fired the shots, because, yeah, he was excluded from the magazine, and he was not the 90% contributor on the gun itself, and it was inconclusive that he was one of the 3 profiles that constituted the remaining 10%. So the way I've been phrasing it is saying he's effectively excluded, because for all intents and purposes, yeah, he is effectively excluded. His DNA is effectively excluded from the gun. So that's, I think, the proper way of framing it. But I think the state saying, oh, don't be fooled when they say he's excluded, I don't know. I don't think that gets to the point of a improper statement. Yeah, I would probably chalk that up just to argument, trying your best to frame the evidence in the way that's favorable for your side. Yeah.
To illustrate this, I want to clarify some key terms in science. So inconclusive, we heard in trial testimony, means it's not positive, it's not negative, it's just a neutral result. But it's not quite as simple as that. Actually, according to the scale of a likelihood ratio, which was in the discovery and presented at trial, likelihood ratios are the percentages. And we did not hear any percentages in Mr. Peterson's case, even though this evidence was available to the prosecution. This evidence was only given to defense upon our expert witness's request. So we did receive this evidence late. So this evidence was not presented in trial. It was presented in the motion for a new trial. But what we can see is that likelihood ratios that are 0, 0.01 and below are considered to be excluded. Likelihood ratios from 10,000 to 999,099 are very strong, very, very strong support to the prosecution that this person did leave DNA on this item. And then above 1 million is very, very strong. We found in the DNA evidence that they labeled Mr. Peterson's LR to be inconclusive and uninformative. And uninformative, according to this scale, is an LR of 1. Therefore, Mr. Peterson had an LR of 1 in a million that his DNA was on this firearm. And with that fact, it is actually marginally more likely that another member of the African-American population touched this gun over Mr. Peterson, which the jury did not hear. The jury heard the district attorney say, don't be fooled. But there's also no proof that Mr. Peterson did anything to fool anyone about this evidence. He presented his defense. It was their testing. We went off of what their testing said. So I just think that that is a very strong contention. People v. Veryman.
So, yeah, unfortunately, when it comes to all of our arguments about the DNA evidence, most of it is a factual analysis. And as I said at the beginning as well, remember, appellate courts are largely looking at issues of law, not issues of fact. And so even though I think we are 100% correct in our pointing out saying that, look, his DNA was not on the gun, how are we going to prove beyond a reasonable doubt he's the one that did the shooting when his DNA was effectively excluded from the gun? Unfortunately, for where we are in this legal process, the only way the appeals court is going to throw that out is if they conclude that it was a clearly erroneous finding of fact by the jury. And it's tough. It's so hard to convince a court to step in and overrule a jury's finding of fact. So that's why she's focusing specifically not on the DNA evidence itself, but on the statement that the prosecutor made about the DNA evidence, because the statement, that is now an issue of law. And now the appeals court can determine whether or not that issue of law, or that statement is enough of an issue of law to constitute a harmful error for purposes of overturning the conviction.
In 1999, 21 Cal 4th to 50 is a significant California Supreme case that addresses the standard for overturning a conviction due to prosecutorial misconduct. It's a principle basically, the key outcome of that case was that we must show that this misconduct materially affected the outcome of the trial. And it did. Because if our jury had heard that Mr. Peterson, maybe 1 in a million, touched the gun, I believe that would have been enough to tip that scale and show reasonable doubt for them to find him not guilty.
But then the question there becomes, why is it the prosecutor's obligation to say that? It's the prosecutor's obligation to disclose that to the defense, absolutely. And if they don't, then that's a Brady violation. But it was here. The DNA testing was disclosed to the defense. The defense had their own expert that testified about his conclusions or his opinions based on the DNA evidence. So just because the prosecutor did not put into the jury's minds that there was a 1 in a million chance, well, that's not really the prosecutor's job. That's the defense's job. That'd be the defense expert's job to make that conclusion and put that in the jury's mind. So yeah, that's not, I would not call that prosecutorial misconduct, because the DA was not arguing that. Although, just as a general rule, yeah, I think there's plenty of prosecutorial misconduct to go around in this case, but I don't think that is one of them, though.
Jury just didn't hear that. They heard that Mr. Peterson hoped that they would be hoodwinked in the alleged closing arguments.
Yeah, oh right, if they never heard the DNA evidence, though, doesn't that influence their decision making? Yes, absolutely, it does, but it's a question of whether, right, the only legal question for us to consider here is, was that evidence disclosed to the defense? Because from there, the burden, or it's up to the defense to use that evidence to make their argument, in pointing out, hey, based on this DNA evidence, it was a 1 in a million chance that Tory touched the gun. So that's very important. The defense DNA expert didn't see it until after the trial. Okay, that's what I'm confused about, though, because I could have sworn that the defense expert testified during the trial. She said the percentage wasn't disclosed till application for retrial. No, exactly. Prosecution did not turn over the STR until last minute. That's why Tory's expert could only agree. Now, when you say till last minute, are you saying last minute during the trial, or last minute meaning during the application for retrial, like KG is pointing out? Because, yeah. Because because here's going to be the basic standard here. If it was a piece of information, piece of data that was not even disclosed to the defense, then yes, absolutely, Brady violation. Could be absolutely grounds to throw the case out. But if it was disclosed to the defense, but it was disclosed in this big, massive report, and the defense overlooked it, then, or didn't argue it properly, then that's not going to be the state's problem. That's now the defense's problem, which, yeah, could go towards the ineffective assistance claim, certainly. But it's going to go back to that same question of, was it enough to affect the outcome of the case? Which I know we all feel like yes. But it's going to be up to the court to make that determination, yeah. It was, if that was led to the case after the jury went in, so. Okay. Then, yeah. Yeah, we'll have to wait and see then, kind of what the timeline is on that.
So due to these statements and the misconstruing of the evidence, we feel that that was a very significant issue in the case. And finally, we feel that the Instagram post, as we discussed in our opening brief, this was a Brady violation. This post was given not only late, but it also was not redacted. It was riddled with hearsay. This post is significant as it also implies a confession, because what we have is actually various people posting, and this was in September of 2020, and they were posting that people were saying that, oh, well, if Mr. Peterson didn't do it, then Ms. Harris must have done it. And Mr. Peterson's social media manager had commented on this post, no, they're not. And so that was used as an admission. But many celebrities don't run their own social media accounts. This is significant because, number one, had that discovery been given timely, we could have provided the statement that was provided in the motion for a new trial by Mr. Farias, stating that he is the one who runs Mr. Peterson's social media account. He made that post, and he didn't ask Mr. Peterson before he made that post.
And that's the reason, that's the reason why this stuff has to be disclosed ahead of time, is to, because, say the defense gets that, they get this screenshot, this comment of Tory confessing in the comment, then the defense now has the opportunity to say, Tory, did you do this? Did you type this? He can say, no, I didn't. Who? And then they'll say, who did? And it's like, probably my social media manager. And then they go contact the manager and be like, did you say this? And then he'll say, yes, I did. And then that now becomes part of your defense, is you have that manager testify, and you can even show like through some data through the app of like who accessed what, when was the post made, what was Tory doing at the time the post was made, to show that he couldn't have made the post, or just like all these extra steps of forensics to prove that it was in fact the social media manager that was the one that posted that. So, all right, STR mixed worksheet was turned over 1 or 2 days before the trial at the request of the defense. Brady. Okay, then, yeah, I can see that, because especially if it's an expert report, because right, if the state is planning on using an expert, then yeah, that's absolutely something that has to be disclosed well in advance, because the defense might want to get their own expert. So perfectly sensible rule. But yes, if you're not disclosing things that your expert is going to rely on until a day or two before, then yeah, that's I'd look at that as another potential Brady violation as well. So how did Tory know that his manager did that, though? I'd say just based on him not knowing, or him being able to think, did I make that post? No, I didn't. So somebody must have made it. And then who else has access to the account? And then from there, just kind of process of elimination down to the manager. They didn't do anything forensic in this trial besides DNA testing. Yeah, no, that's true.
So that right there, we could have, if it was not late, presented a defense. But because we didn't have that, we were caught off guard. We were always in a position of reactive instead of actually being able to produce a good defense on this case.
Yep.
The Brady rule provides...
Let me just ask one question on one thing you said. Were there requests for redaction of that exhibit or the post?
I believe there were, yes. Mr. Medesian did do a very good job objecting throughout the trial. We also must remember that Mr. Medesian only took over this case 2 weeks to a month prior to the start of the trial, because the first trial attorney did withdraw and was permitted by court. Yet, I understand the court allowed that, but as an attorney, that's a very big feat to step in the shoes of another attorney so close to the trial. So I feel that all of these arguments we're discussing today, we do need to take that into consideration overall with them and think, in the alternative, this could be an effective assistance of counsel. But the Brady rule provides...
Dang, that's a hard sell. Think about what she just said. She just said, Mr. Medesian did a beautiful job throughout the trial objecting, and it was a tough situation to be in, that he had to take over just 2 weeks before the trial. But he did a beautiful job just objecting and doing what he could. But alternatively, if you find that there's an ineffective assistance of counsel, that he was objectively ineffective in his job, such that it lost the case for his client, then you should throw this case out. So, beautiful job. On the other hand, he was ineffective. Yeah, it's but I mean, that's what you got to do as an appellate lawyer. That's especially if she works with this trial lawyer, because that's the thing. Usually, lawyers will do one or the other. It's rare to have a lawyer that will do trial work and appellate work. Usually, yeah, you try and specialize and focus in. Like, I just do trial stuff. I don't do anything appeals now. I did back in law school, but now, yeah, I'm just all trials all the time.
This exculpatory evidence must be provided to defense whether or not a request was made. The suppression of this evidence, it doesn't matter if it's willful or accidental, so long as it was suppressed, then that is the problem right there. And I do have a 3-part test, which is found in the United States Supreme Court in Strickler v. Green, which is 527 U.S. 263 in 1999. They reiterated the 3 components of a Brady violation. The evidence must be favorable to the defendant. Here, yes, the evidence was favorable. Had we gotten that Instagram post earlier, we could have brought that declaration in trial saying Mr. Peterson doesn't run his own social media accounts. Had we gotten the DNA evidence and not had to request that from the prosecution, we could have prepared for a better DNA argument having the full picture. Had we had the testimony, the transcripts from Ms. Harris's interview, we could have countered that. We could have questioned her on cross about her interview. We also likely did not get fingerprint evidence on time. We did not get, and the fingerprint evidence actually showed that Mr. Peterson's fingerprints, were not found on that weapon. Currently, we are attempting at the Superior Court to have them run the serial number to identify the owner of the weapon, which was not done. And we are also attempting to retrieve either a recording or a transcript of one of the key witnesses' testimony one of the key witnesses in the case, Mr. Sean Hawley, who gave testimony, we're attempting to get a copy of his 911 call.
Wait, you said Sean Hawley?
Sean Kelly.
Oh, okay. I'm sorry.
Yeah,
I think
I'm about to say Sean Hawley. That was the lawyer, the reasonable doubt lawyer. But no, yeah, Sean Kelly. That was the neighbor. But yeah, ineffective in for the areas that he should have objected and for not being able to present a good defense for Brady. Yeah, and certainly it's not mutually exclusive. Like, yeah, you can be objectively competent and reasonable in parts of the trial and therefore effective, and objectively ineffective during other parts of the trial. So yeah, that's certainly, yeah, they're not mutually exclusive, but it does create a bit of an irony there, where they did such a good job, but also they did such a bad job that you need to throw this whole thing out. But yeah, no fingerprints on the gun. Yeah, no, that's another big part too. I don't know if we're going to get to that as well, but I've heard chatter about that was never presented by the state.
Very
who's female.
Yeah, no, very close. Yes, Sean Hawley was the attorney. Sean Kelly was the witness.
Okay, got it.
Different spellings also. So obviously we can see that this is favorable. The second question under that three-part analysis with Strickler was it suppressed, willfully or accidentally? Yes, this evidence was suppressed. All of these different pieces to where Mr. Medesian said, I feel like every day I wake up and I have an email from either the night before or the morning of saying, oh, we missed giving you this. And very respectfully, I say that. And the final component of this three-prong test is, would it have changed the outcome of the trial? Yes, absolutely. If our jury could have heard the full picture, the full accurate picture of just the evidence being laid out as it was, without these don't be fooled and late discovery, I feel that it would have really tipped those scales to reasonable doubt to find that Mr. Peterson was innocent. And that's why today we humbly pray for exoneration of Mr. Daystar Peterson.
Thank you very much.
Thank you.
Okay. Hey, really good job. Really good job of this attorney. Yeah, very well done. I think, seeing that her whole argument took about 25 minutes, spent about that first 10 minutes on that confrontation issue, which I think is the biggest issue. And so if you spend 40% of your time on it, that's a good place to be. And it's kind of like I keep saying with this case is the best thing we can do in being advocates and being defenders of Tory is to focus our fight on the issues that are the best for us. If we get sucked down into these other issues that are not as strong, then all we're doing is playing into the game that the other side wants us to play into. We're going into their territory now to fight on ground that they are more comfortable on. I say, no, don't do that. Pull them into the ground that we're most comfortable on, which has to do with the DNA evidence, has to do with Kelsey's statement coming in, has to do with the gunshot residue, that has to do with all the witnesses, Bradley James, Jaquan Smith, all of these witnesses that all are saying the same thing. Focus the fight on the grounds that are the most convincing, most compelling, and that's how we're going to win people over. The best, yeah, and you can see that's basically here. This is the Super Bowl here. This is the most important day in Tory Lanez's case since the trial, because this is the opportunity here to have it overturned. And she had 25 minutes to make her case, and she kept it very focused on the issues that are some of the best arguments that her team has, that Tory's team has. So didn't get sucked down the rabbit holes into different arguments. Kept it very tight, very focused. So yeah, very well done, this attorney. But obviously we got more time, so I'm assuming the state is going to give their rebuttal next. So let's see.
Morning, Your Honors. May it please the Court, Deputy Attorney General Michael Keller for the respondent. I want to begin by discussing the compelling nature of the evidence in this case. Within minutes of the shooting, the police found the gun that was used under Appellant's seat. There were only 4 people in the car. Pete and Harris both identified Appellant as a shooter. That first ID occurred within minutes of the shooting when Harris sent a text to a member of Pete's security team saying, "Help, Tory shot Meg, 911. Harris again ID'd Appellant as a shooter in the recorded statement, and we can get to that in a moment. And Pete identified Appellant as a shooter both before trial and at trial.
All right, I can already tell his strategy here. He's basically just trying to go over the facts again and give the most favorable facts that the jury used to convict. And it's not a bad strategy. It's basically trying to get the appeals court to say, look, This case is over and done with. They're grasping at straws. Don't listen to what they're saying. They're trying to pull some legal mumbo jumbo. Just focus on the facts and let the jury's verdict lie. Let it lay where it is. Don't get involved. Just dismiss this and let's all just move on with our lives. So very fact focused to begin with, which I can understand why he's doing it, but I'd love to hear his response to her issues of law that she's raising.
Neither of them ever suggested that anyone other than appellant fired the shots. Now, there's 3 times in which appellant tacitly admitted being the shooter. The first is hours after the shooting, appellant made a recorded call to Harris stating that he didn't even remember what they were arguing about, and he wanted to know the hospital where Pete was being treated. He blamed alcohol for the quote-unquote shit that he did. Now, the second one was later that day, appellant sent a text to Pete, to the victim, and that text was preserved. In it, appellant said Pete would probably never talk to him again, that he was sorry, and he blamed again the alcohol for the quote-unquote shit that never should have happened. And then the third and final is the verified Instagram post that I'll also get to. Now, appellant's assertion is that he really wasn't accepting blame for having shot Pete, but for causing a rift in the relationship between Pete and Harris. And that's just nonsensical. First of all, Harris told appellant she was at the hospital waiting for Pete. So if there had been a momentary rift that night, it was over because she's now at the hospital waiting for her friend.
A momentary rift? You mean Megan curb stomping Kelsey, pulling her hair out, scratching her, breaking her bathing suit, breaking her nails? Like, if there was a momentary rift, it was repaired. Yeah, when a gun gets involved and you almost shoot the girl, and yeah, of course, yeah. A momentary rift. Oh my god, that's my favorite. That's my favorite way I've heard anyone describe the fight that night.
She's known for 7 years to be released and checking on her. Second, appellant didn't apologize to Harris, but yet he anticipated that Pete would never talk to him again. He was clearly accepting responsibility for something very big, something that applied to Pete, but not to Harris. And as appellant said he couldn't remember what they'd argued about, he wasn't accepting blame for anything he said. Finally, appellant said that he expected to receive backlash once word got out. Now, backlash for causing a rift makes no sense, but backlash for shooting someone does. The evidence in this case was compelling. Turning to a few of the issues that...
Yeah, I mean, and I won't lie. There are facts in the case that do sway towards Tory's guilt. I've always said that. I've always maintained that there are facts here that point towards guilt. I just think that do they get anywhere near the level of beyond reasonable doubt? Absolutely not. It is so far away from beyond reasonable doubt. Like, there are just so many holes in this case of reasonable doubt that. But I'm not like I've always been with y'all. I'm always fair, always transparent, always honest. I'm not going to deny there are some facts that certainly do seem to swing towards guilt. But yeah, it is just nowhere near enough to convict here.
Have been highlighted here today. I'll start first with the Instagram post. This was appellant's verified account. And a few times today I heard opposing counsel mention Brady, but Brady was never mentioned in appellant's opening brief or the reply brief. It can't be raised for the first time at oral argument. And frankly, it has no application here because the things that were turned...
Was it not? But I'm pretty sure we touched on Brady in here. Hold up. Oh, wait, can I just not find any word? Oh, I can. Okay, maybe he's right about that then. I could have sworn I saw something about Brady in here. Or maybe it was just kind of more of a subliminal reference to something that could relate to Brady. Yeah, I forget. Oh, well.
Over were inculpatory, not exculpatory. So when it comes to the Instagram posts, they were turned over upon realizing them, and there was no, many of the case, as you'll see in the response brief, many of the claims that appellant raises are forfeited by a lack of objection at trial.
That is important. That is very important. The way you get into an appeal is you have to do what's called preserving the issue, meaning at the trial, you either have to make a motion to do something, and then that motion gets granted or denied. That can be an issue that you can appeal, or an objection. You can object to something happening. The judge can overrule your objection. But the fact that you objected, that has now preserved the issue to be reviewed on appeal. So I don't know how much of what happened was preserved for objection. This is also part of the reason I just haven't gotten too deep into this appeal until today, is we're talking about, for me to give you the true full breakdown, I have to read the entire court transcript from the trial to see when the objections were, mark all those down, and then I have to read the defense's brief, the state's response brief, the defense's second response brief. It's a lot. It was a lot of work, which is why I was like, let me just hop on a stream and we can just go kind of talk about all this together. But either way, so I can't speak one way or another on whether or not the issues were properly preserved for appeal. I'm assuming they were, since we're here, we're having this argument. Yeah.
And one of the things Your Honor asked is, did counsel ever ask for redaction? I don't see that anywhere in the record when it came to the Instagram post. In fact, counsel didn't even object on the discovery basis. The objection was solely based on foundation. So discovery doesn't work for appellant on appeal. And as to foundation, the question really is whether or not there is an inference that can be drawn that a statement was made by a party. If so, it falls under the party opponent exception to the hearsay rule. And in this case, it's a verified account. And the fact that there may have been somebody else who had...
You know what this is giving? This is giving Boomer, which certainly seems like a bit of an older guy. It's giving Boomer who doesn't know how social media works, or particular how social media for celebrities work, and how more than one people have access to these types of accounts. I mean, there was even a time on this channel I was working with an editor for a little bit, which I'm probably going to start doing moving forward again, just to have someone who can chop up these live streams and post videos out of them and do the thumbnails and all that good stuff. But yeah, during that time though, me and him both had access to the channel. So if you were to go comment, yeah, it's giving Boomer, you tell him, Queen, thanks. I try. But yeah, it's like, this is a verified account. This is his account. What do you mean? It's like, he's probably, the only thing he's probably got is a Facebook account. He probably had to learn what Instagram was just for purposes of this appeal.
Access to it to respond and may or may not have had permission. That would all go to weight, not to admissibility. Turning to the issue raised about the Harris recording.
Real quick, it just hit me what he just said. Let me go back for a second.
That would all go to weight, not to admissibility.
I use that so many times as a prosecutor. That is the get out of jail free card on the state side. Is like, Your Honor, even if there was an issue here, it doesn't go towards admissibility. It just goes towards weight, meaning the issue is not whether or not the evidence comes in to the jury. The issue is how much weight the jury is going to give it after they receive it. So yeah, it's just funny to hear him say that. Like, even at the highest levels of California is a very big state. These are good lawyers here. To hear them using the same, it's the famous stateside get out of jail free card.
Turning to the issue raised about the Harris recording.
Let me ask you a question about the Instagram post before you move away from that. And I guess the question is, if there were some sort of error in admitting that post, what would your argument be about as to whether that was prejudicial or not?
Yeah, it certainly wouldn't be prejudicial, Your Honor, because, first of all, at trial, it came out about these other aspects. In other words, do we know for sure whether or not this was appellant personally authored or approved of it? There's some question about it. But what we do know is he did send the text. What we do know is he did make the recorded phone call. Like, that's his. You're
right, T. He just made her point here about, even if we don't necessarily know who made the Instagram post, well, he's pivoting. He's pivoting to the stuff that we do know came from Tory, which was the text to Meg and the jail call. Yeah, those did come from Tory. But look how he's trying to pivot to get to his comfort ground. It's like what I'm saying about we need to fight on the grounds you're most comfortable with. Yeah. And so look, he's doing it in real time. And one might say it's some good lawyering right there, but we'll see if the judge picks up on it.
His voice. So, and by the way, I would say that on the Instagram post, the post, all it said was, Harris didn't do the shooting. He didn't say, I did the shooting in that. So it's no more incriminating than the other admissions that came from his phone in a text or in person in a voice recorded call.
Yeah, but those are the only two people that were there. The only two people who could have been the ones that did the shooting. So him saying that Harris didn't do it, by definition, is to be treated as an admission that he did it. at least in the eyes of a jury.
So turning to the tape-recorded statements that were made by Harris to impeach her as prior inconsistent statements. When she was on the witness stand and made a number of inconsistent statements, the prosecution impeached her with those prior statements. Much of the pieces of the recording came out during that period of time. While she was still on direct exam, the prosecutor announced a desire to play the entire recording at a subsequent time. And that's 5 RT 3664 through 3665. Now, this puts the defense on notice that the entire recording is going to be played. The defense has an opportunity to object to it, to portions of it, and counsel doesn't do so.
But why? That's such a technicality, though. You're saying because Tory's lawyer did not object to the prosecutor when he stated that he wanted to play the full video. Why is that the time to object to that? Why is it not the time to object when it actually comes in front of the judge and the judge has to decide whether or not to admit the full video? Because that's something that would happen later. Just saying you intend on doing something. Well, I intend to object. It's like, what? No, you don't go based on what happened in the future. You go based on or what might happen in the future. You have to go based on the moment. Yeah. Oh my gosh.
Counsel instead has an opportunity then to cross-examine on anything and everything that's in the recording because counsel knows that the entire recording is going to come in.
But how do you cross-examine on the recording? Because who's in the recording? It's Kelsey Harris. It's her recorded statement. How do you cross-examine her about that recording if every question you ask her about the recording, she pleads the fifth to? Or she says, I don't know, I don't remember, or I lied. It's like, okay, I need to calm down. Take a breath. Let's, Your Honor, I had a premonition of the future. Exactly. I future object. Lawyer, I should just do that at the beginning of my next trial. I just say, Your Honor, I object to everything that will come up in this trial that's objectionable. And boom, there we go. That'll just cover me for the entire rest of the trial.
So a confrontation clause claim just doesn't lie. And then I would add that on top of it, Harris wasn't excused as a witness. At the end of Harris's testimony, I see nothing that would preclude Harris from recall.
Okay, recall her, and then what? She gets recalled and she gets back on the stand and then continues to just plead the fifth and not give you any information. Please tell me one of these judges is going to ask him about this, because like I said earlier, the confrontation clause issue is the biggest issue, I think, of this entire appeal. I think it's the strongest argument, the strongest claim that Tory has for getting it overturned. Yeah, that's why she spent 10 minutes on it. He spent about 30 seconds trying to rebut it and did so poorly. Yeah, please tell me we get a judge. I see Tia saying spoiler alert, so maybe I hope y'all don't think I actually secretly watched this ahead of time. I swear, I did not watch this yet. But maybe it's this one. She looks like she might be putting her hand up to try and get his attention.
So a confrontation clause is for...
But she's been on and over here with the good questions, though.
When the defense doesn't have an opportunity to cross-examine a person on it, Harris testified. Although Harris initially took the fifth, Harris was given immunity, subsequently testified. So the confrontation clause just does not work on appeal. And lastly, I'll turn to the allegations of prosecutorial misconduct. On that, again, these are forfeited claims. Objections weren't raised. Your Honor asked a question about how do we know on good faith, bad faith versus, there was a body attachment. You have a prosecutor that is, because the trial court did inquire into it, and the prosecutor said that the witness was under subpoena, and the prosecutor said they had a good faith. That's a judgment for the trial court. Now, I would note that the defense counsel wanted... So
is that the admission there, that the only contact they had with Justin Edison was that they had him under subpoena, meaning they sent him a subpoena and expected him to be there? Because if that's yes, a subpoena carries with it the force of law, and if you ignore a subpoena, there can be actions taken to try and compel you to comply with the subpoena, specifically in a criminal case here. So there can be consequences for that, but yeah, if you fire and forget a subpoena through the mail, and yeah, you're just expecting them to be there, yeah, that's weak sauce. That's flimsy.
more information about it, that was the time to raise it and to try to develop more details right then and there before the ruling as to whether or not this witness was going to be available and whether the prosecutor actually had a good faith. And the defense's failure to do so precludes the claim from being raised on appeal. And one of the things I'll note that is in the reply brief as to these allegations of misconduct that weren't raised below, the reply says, well, an objection would have been futile because it would have run the risk of highlighting the issue for the jury. That's not what decisions involving futility involve. The futility exception applies only if the record shows that the objection would have been overruled or that nothing could have been done in a curative fashion, not just that it might highlight an issue for the jury and the attorney had a tactical reason for not doing so.
That's just a tricky tactical decision for a defense attorney to make, really any attorney in trial, is, yes, when you object, oh, sorry, quick side note, like you can see the top of his head. Oh. So I shouldn't be making jokes. I shouldn't be laughing. That's going to be me, probably in the not too distant future. But either way, tactical decisions to object or not object. Yes, it certainly, there is some strategy to that, because if you object, then yeah, you're kind of impliedly highlighting the issue for the jury. And it could be something that you're hoping just kind of flies over their head, and that'd be the best case scenario. But then if it doesn't fly over their head and then it's held against you in a very strong way, then you're going to say, dang, I wish I objected. So yeah, it's just a tough situation to decide object or not object. The safer route is going to be to object, I would say, but certainly there can be situations where it's not going to work. But laughing at me, oh my gosh, sometimes I look at the top already and I'm like, oh geez, it's getting a little thin up there. But it's just because I get so stressed out laughing with you. Thank you. It's just because I get so stressed out fighting for justice, truth, justice in the American way. But yeah, also I am quite tall, so I would be the one to have my head sticking up just into frame of the of the camera. Yeah.
Unless the court has any questions, I'm prepared to submit on the brief and ask this court to affirm the judgment.
We have none. Thank you very much.
Thank you.
I'm disappointed. I wanted some good questions out of that. And that's the hack. That's the cheat code too. Is the questions that a judge asks are really, really where they're really valuable, because that's the easiest and best way to see where's the judge at right now, what issue concerns them the most, and you want to be able to give good answers for the questions.
Any rebuttal?
Yes, briefly. Regarding the text to Mr. Edison, there was actually a motion in limine filed regarding that text. It was filed on December 12th, 2022 by Mr. Medesian. He stated that without Mr. Edison present in trial and without the foundation laid, that this text message shouldn't be admitted. That objection also was not granted by the court, but was on the record nonetheless. I've heard the people say that there was compelling evidence to find Mr. Peterson guilty, but I argue that there was not enough evidence, because we talked about physical evidence in this case and the lack of physical evidence in this case.
Yeah, that's why I see the comment, Keontae. What do you think about him not bringing up any points about the DNA and fingerprints? I imagine, sounds like to me she's about to get right into that. My quick take on that would just be he kind of recognizes where his bread is buttered, and he's not going to go down the rabbit hole down the weak evidence, which to me is once again a very strong acknowledgement. It's implicit, but it is strong nevertheless, that the DNA and the gunshot residue and the fingerprints, that is all strong evidence for the defense, which is why he said, I'm not even going to touch it. I'm not even going to bother with it, because it's just going to put him in a bad position. So yeah, he knows where his bread is buttered. He's only going to focus on the evidence that is strong for him, or at least the strongest for him. So I'm expecting, sounds like she's about to get right into it and talk about, yes, he has facts that help his side, but I have facts that help my side. And when you balance them all out, we're nowhere near the burden of beyond a reasonable doubt.
We discussed the variance in testimony, where even today, it's still not quite clear what happened on that night. And I also want to talk about the Instagram post. The fact that Mr. Peterson didn't say, well, it wasn't Ms. Harris and it was me, that really doesn't matter. There were only 4 people present the night in question. One was Mrs. Pete, 2 was Mr. Harris, and 1 was Mr. Harris. That really doesn't matter. There were only 4 people present the night in question. That really doesn't matter. There were only 4 people present the night in question. One was Mrs. Pete, 2 was Mr. Harris, and 1 was Mr. Harris. That really doesn't matter. There were only 4 people present the night in question. One was Mrs. Pete, 2 was Mr. Harris, and 1 was Mr. Harris. That really doesn't matter. There were only 4 people present the night in question. One was Mrs. Pete, 2 was Mr. Harris, and 1 was Mr. Harris. That really doesn't matter. There were only 4 people present the night in question. One was Mrs. Pete, 2 was Mr. Harris, and 1 was Mr. Harris. That really doesn't matter. There were only 4 people present the night in question. One was Mrs. One was Mr. Smith, who was the driver, leaving only Mr. Peterson or Ms. Harris in possession of that weapon doing the acts that we're here for today. Therefore, it doesn't matter if he didn't confess. It was an implied confession because there was no question as to whether Mr. Smith or Ms. Pete ever did these actions. I would like to remind everyone that Brady is willful or accidental. Brady says that regardless, the defense has a right to the evidence that's being produced against them in court. The incidents were very significant. The pieces that we were not given would have changed the outcome in this trial. For example, with the Harris recording, there also was an objection there for the Harris recording. That goes back to our motion in limine on December 5th. And in that, when there also was a sidebar as this was going on and these statements were being played to first refresh Ms. Harris's memory, Mr. Medesian did object and there was a side.
And that's what the assistant AG, he even kind of referenced that of like, look, the portions of Kelsey's statement, they were just being played just to refresh her recollection. But if y'all remember what I was saying earlier about a judge giving a limiting instruction, it's like, what good is a limiting instruction? Say the judge lets in the entire video, but gives a limiting instruction saying, all right, jury, just so you know, this whole statement that's coming in, you're only supposed to use it to impeach her credibility as a witness. You're not supposed to use it to determine whether or not anything she said in the video is true or not. Well, when you hold up her video compared to what Meg already testified to, then just, of course they're going to take what was said in the video and hold it up as like, well, okay, this must be her testimony. So yeah, in fact, he even referenced that as like, well, and at first the portions of the video were just being played to refresh her recollection. It's like, okay, maybe like on their face, like facially, the reason was for that, to refresh recollection, but we all know what the real reason was, and it was to try and shoehorn in through a back door this testimony that you were not being able to get through the witness that you called to testify.
And the judge actually commented that it's just easier this way. And Mr. Medesian said, but procedure. And the judge said, no, it's fine. We're going to do it this way today.
Yeah, and I certainly understand as a judge, your job is to call balls and strikes to make sure the process is fair and to uphold procedure. But part of upholding the procedure is protecting judicial economy, meaning making sure things move along at a speedy enough pace. And it calls me back to the Young Thug RICO trial, how they were literally in trial for over a year before and the judge even had to get removed from the case and a new judge put in before it finally got thrown out. But yeah, you want to talk about just taking forever and going so slow. So I certainly understand a judge that wants to maintain judicial economy and move things along, and it's a valid feeling to feel like, well, it's just easier this way. Let me just let it in. It's easier this way. But when we're talking about procedure and constitutional rights, I'm sorry, but judicial economy does not trump someone's constitutional rights to a fair trial.
So those objections were raised in the courts. Those weren't waived. And honestly, as far as recalling Ms. Harris, there was no body attachment. She stated, I don't want to be here. I don't want to do this. She stated, I have not been truthful. And that's, I can't speak for Mr. Medesian. So there is no record of why or why not she was not recalled. But I feel that the people did just make a good point that it was futile. I feel that at this point, Mr. Medesian, very respectfully, did feel defeated. He did feel overwhelmed. He stated in his objection, I wake up every day and have an email from late last night or this morning with another piece of evidence that the people forgot to give us. And I do feel that he lost some of his steam there, so to speak. And because of that, that's why I reminded the court that he had a very short time to prepare, and any objections that were missed should be construed as ineffective assistance of counsel. And in that I submit.
All right. Thank you both very much. The matter stands submitted.
All right, well, that's it. There's the oral arguments for the Tory Lanez appeal. Let's see. In hindsight of all that, well, let me go through these comments first. 80-minute interview that was supposed to forget was not in judicial economy. I see what you're saying. I'm looking at it, I think, a different way. So I had a case as a prosecutor where we had about 80 minutes of video of this guy's Facebook posts that we didn't want to play the entire thing. We kind of wanted to just play the highlights to give the judge the idea. It was a cyber stalking trial. And basically this guy was just making these very crazy, obscene Facebook posts about one particular person. And we didn't really want to have to play the entire 80 minutes. I was trying to just pick and choose what the... let me do this while I'm talking with y'all. I wanted to just kind of show the highlights to the judge for that. But the judge was actually just getting more confused than anything. And so he was like, can we just watch the whole thing? And I was like, okay, fine. So our attempts to streamline it and make it go faster would have just made it more confusing to try and pull the different clips. And so it ended up being the fastest thing to do to just play the whole thing. So, yeah, Lyrex knows what's coming next. But I got to finish my wrap up on this case before I let you all know what we're going to do next tonight. But so yeah, I can certainly see it's like judicial economy. In this situation, I could have totally seen where you've got this witness who's being uncooperative. You're trying to refresh your recollection with bits and pieces of this recorded interview, and you can just get to a point where it's like, F it, just play the whole interview, and that way it can just be done and we can just move on. Yeah, it'll take 80 minutes, but at least after that we don't have to. That compared to it might take 180 minutes to try and to not get anywhere near as far, trying to just continue asking questions about it. But yeah. How do you play a recorded interview after Kelsey left? You can't cross-examine. Well, that's the thing. Even if it was before she left, how are you even supposed to cross-examine her if she's just pleading the fifth to everything? She's refusing to answer the questions. So even if the interview was played, say the whole interview was played while she was sitting there on the stand, there's nothing that Tory's team could have done. There's no questions they could have asked her that she would not have said, I plead the fifth or I don't recall. So yeah, there was no utility to that. But played parts when she was there, but the whole interview after she left. Yep. He did that. Judge told him not to consider it. Judge told him not to consider it. Yeah. That's different though. Kelsey admitted to lying in that video, so it shouldn't have been used. So yes. So I agree. That's why my position on this is completely that the video should not have come in. And I think the fact that the video did come in, I think that's enough to get us to the point of overturning this case, which I guess brings me to my closing thoughts on the Tory case, or on the appeal, is I think there's enough there. I think there's enough there for the court to, if not outright overturn the conviction, at least to remand basically on some of these objections, where that's one of the other options that a court has. Instead of outright throwing out a conviction, what they can do is remand the case back down for a new trial. And a new trial with some specific guidance on, hey, prosecutors, this video that y'all played that the judge can't let come in, that video cannot come in. So adjust accordingly. Honestly, if I had to guess, I think based on hearing these arguments and hearing the state's response, I would not be surprised at all if the outcome here is this gets remanded for a new trial with direct instructions that some of the stuff that came in not come in on the second time around. That's my feeling, but it's so hard. It is so hard to try and nail down these appeals court judges unless you have, because usually big issues, they get resolved at trial. Almost all the big issues are resolved during a trial. So for there to be a big enough issue that's enough to change the outcome of a case on appeal, for it to have not been resolved at trial. Here's the thing about trial judges. The thing they hate the most is getting smacked down on appeal. And so that's why that's their main motivation for having a fair trial, having a good trial, is to protect themselves, honestly, and protect themselves from getting overturned on appeal, because it's embarrassing and it cuts against their just professional reputation as a judge. And judges, they're inherently usually pretty ambitious. They're trying to make the climb themselves. And if you're a judge that wants to make it to the appeals court or maybe the state Supreme Court, then what's it going to look like on you if you're constantly getting overturned on appeal? So judges are trying to do what's right, trying to be fair. And so most issues get resolved during the trial in a way that is not overturnable on appeal. Even if usually they make the safe play. So the fact the judge let some of the stuff in, to me, is not the safe play. And I think he opened himself up to getting potentially overturned, or at the very least getting a remand order to have a new trial. So we'll see. We'll see what happens. The next thing that will come down is the appeals court will issue a written opinion explaining what their verdict is, what the outcome is, and from there we'll go from there. So right now we're just sitting, waiting until we get that opinion. And so that's all I wanted to cover for today for the Tory case. I know most of y'all are here for that, and thank you all so much for being here once again. It's way bigger turnout than I was expecting, so super grateful, super thankful for all that. From here on, well, let me finish out these comments. Yeah, Kelsey said she was not truthful in interview. Yes, true, but pretrial testimony shouldn't supersede her under oath testimony, in my opinion. Absolutely right. Yeah, no, that's my biggest argument here, is that her on stand, under oath, under penalty of perjury testimony is her most reliable. So if she's pleading the fifth or saying she doesn't recall, then that should not have come in. Doctor never showed up. Didn't get much of that in this appeal argument. Desiree Perez was in Kelsey's interview. Ooh, okay. Very spicy, very spicy. Yeah, I need to get caught up on the DeMore Hadley lawsuit. I know I've been following it a little bit, trying to stay up with it, but that's the thing about court cases. Like, there's so much information, and it comes out, or when it does come out, it's usually a lot of information that comes out. So that's one I need to get caught up on. Chicken and our friends over there at Rock Nation and Desiree Perez. So if prosecutor doesn't want to try it again, then what happens? Great question. So if the case gets remanded for a new trial, and the prosecutor does not want to try it again, then they have full authority, full discretion to drop the case and not try it again. In fact, sometimes that is exactly what happens, because it's basically, think of the Young Thug trial. It took a year to prosecute that case, and it still ended up getting thrown out anyway. But say it led to a conviction, and the appeal goes up, and they remand for a new trial. At that point, the DA's office has to make a conscious decision. Do we want to spend another year of time and resources prosecuting this case again? And yeah, odds are probably not. So it'll be a decision for the LA DA's office to decide. My guess is they would prosecute this. It's too high profile, and it's also too I guess compact. It's a very, very short set of facts in regards to the night in question and the shooting. So I would imagine they would try it again, if nothing else, just for the publicity of it. But certainly they may decide to not try it again, and at that point it would get dismissed. So hope they unseal the 911 call. Hopefully everything. Yeah, hopefully. KG, Rock Nation CEO, is it safe to speculate possible coercion and reasons she was untruthful in the first interview? I'm not going to speculate on that, just because I know how Rock Nation likes to get in Desiree Perez. So I will plead the fifth in that occasion on why Desiree Perez was involved. But certainly we can draw our own inferences, draw hypothetical conclusions as to why Desiree Perez and Rock Nation were so interested in this trial and the steps they may have taken to ensure a favorable outcome for them and their client, Megan Thee Stallion. So, sorry, my plan was to go through all the comments, but you guys keep commenting, which is awesome. But can I get through all of them? Let me see. Can we play the act deposition? LOL. How long is it? Because I've seen some of the clips from DJ Academic's deposition with Rock Nation, but I don't know how long. The whole thing is. So maybe that comes next. Let me see. Thank you so much for coverage of my arguments, Crystal Morgan. Thank you so much for coverage of my arguments. I was being quiet as I wanted to see your honest opinion. You're reading my mind. We can't guarantee an outcome. Everyone pray. Agreed. Yes, everyone pray. Rap battles rule. Check out Academic's deposition. Yeah. Okay. That may have to do what we do next. Crystal commented. What else did I already read it? Yeah. Hi, TNP sent me the link. Oh, thanks for being here, Crystal. Much appreciated. Yeah, just all y'all for being here. Lyrax, no, quick, everyone keep commenting. I'm trying to engage with everybody, but there's too many. I'm drowning. It's like 8 hours. Oh gosh. Okay. We'll see. Maybe we take that in chunks. Yeah. Crystal Morgan, the appellate attorney, is here. Oh wait, yeah. That's right. Crystal Morgan. Wait, so you're the... That's right. The Crystal Morgan. Awesome. Yeah. Everyone, this is Crystal Morgan in the chat. She's the one that we just watched argue. So everyone say hi to her and tell her how good of a job she did. Because I don't know when you got in here, but yeah, I thought it was excellently done. I think it was very telling when the assistant AG got up and basically just tried to focus so hard on the facts of the case when it's like, yeah, there's going to be facts. There's going to be facts that are beneficial to both sides. But we're not here to really argue the facts. We're here to argue the issues of law. And I thought especially the fact that you spent the good first chunk on that confrontation clause issue, which I think is just the biggest issue, the biggest argument that you've got. And so I thought that was perfectly articulated through the beginning, spending as much time as was needed to get on it, to get in on that. And then the most telling part was the AG's response was like 30 seconds, basically just saying the confrontation clause doesn't apply here. And it's like he had no argument for the actual merits of the issue. So yeah, so I think this went really well. I explained to everybody that the bulk of appellate work is won and lost in your brief, and I have not read the full brief, but I'm planning on it. And so, as good or as bad as oral arguments may go, you could have the worst possible day in oral arguments, but have an awesome brief and still win. So it's really going to come down to that. But as far as bolstering the case through oral arguments, then it was really, really well done. So big shout out, Crystal. Let me see what else. 8 hours on the academics deposition. Whew, that's going to be. Yeah, it's such a great case. You don't get to argue facts like this every day. Tia and Fee work with me. With the sunglass emoji. Wow. So hip, so cool, awesome. Yeah, that was the vibe I got too from the AG was he came off like a boomer who doesn't understand social media or celebrities at all. He's saying like, this is a verified Instagram account. And it's like, yeah. And I'm a YouTube channel with like 1.6K subs, and back when I had like 600 subs, I started working with an editor for a little bit. And it's like, I had two people who had access to the account. So we're talking about like big time musician. Yeah, there's gonna be multiple people with access to the account. So just because it's a verified Instagram account, yeah, it was. Yeah, the AG, I thought he was pretty funny. Yeah, though. You guys have any questions for Crystal while she's here? Because, I'll ask. What's our timeline? What's our, when are y'all expecting to get an opinion back? Let's see, mods give shout out to Crystal Moore. Yeah, that's right, Lyrax. Thank you. Just first comment in your chat. Yeah. That's why I said at first an apology isn't guilt, and the confrontation clause was my favorite too. I'm so glad to hear you say that. Fingers crossed. I've been working on this for 2.5 years. Yeah. No, I bet. This is I was explaining to the chat a little bit as well. Like that's how these things just take so long to play out. That's why I didn't want to speak on when we might expect, because I'm in North Carolina, so I don't know the California system anywhere near as well as you would. But so no idea when we might be expecting an opinion back or the timeline on that. But yeah, even if it's just a remand for a new trial, I still think that's a huge win. Even if it's not outright thrown out. Thought decision was already made. He's supposed to get out already? Is that? Let me see. Still serving. Appeal is ongoing. The main part of the appeal not yet ruled on. Yeah. The habeas petitions were rejected. Focus on new evidence. Yeah. So no, we're still waiting on the bulk of the appeal we just watched. We're still waiting on that outcome. He deserves anything that gives him his name back. Yeah. Well, here's the crazy part. As much as like, this is what sucks so much about this case, is obviously we have our legal outcome, which was a conviction, and he's serving 10 years for it. That's why T and Fee know so much. After hearing that AG wanted to keep arguing about Brady, LOL, and it is anyway up to 90 days. Okay, cool. So we should have an answer, all things considered, relatively soon. You know, when we put this in the context of a 2.5 year window of preparation to get to this argument. to have a decision necessary in 90 days. That's good. That's fairly quick when it comes to these types of things. So that's awesome. But what was I saying? Oh yeah, that's what sucks the most about this case is obviously we have our legal verdict, which is the conviction. But aside from like the few, I guess, YouTubers that we see and whatnot, like Alvin Preach and Anthony Fantano and I guess Charlemagne as well, it's like, yeah, some of the power players, they're all talking about how this appeal's going nowhere and yeah, he should have been convicted. It's like, I get it. They're trying to play buddy-buddy. They're trying to play nice with these big corporate groups. I mean, Rock Nation is a very large group. You don't want to step on their toes. But when you look at the actual like people and then people like DJ Academics, but also just the people like you all in the chat, or just all across Twitter, it seems like the huge overwhelming consensus is that it should not have been a guilty verdict. And yeah, so so when we talk about the court of public opinion, which is kind of what we're in largely, that I try and tie it into the court of law as much as I can. But the habeas were too bad, but I do get it, and the Racial Justice Act survived in the writs too. Okay, cool. So there is some stuff that survived in the habeas petitions. Yeah, I need to. I really need to dive into the into those. I haven't looked into those at all. The TLDR is I'm just getting back into content. Been crazy, jam-packed, busy the last few months actually. But yeah, definitely have some catch up to do with this case. But yeah, so the court of public opinion I feel like has already exonerated Tory, especially with the news of the stabbing. It feels like pretty much everyone's on his side. Like the sympathy is all there. But what sucks is that no amount of sympathy, like no amount of overwhelming sympathy, will cause, if there's not also legal grounds, will cause an overturning or cause him to get out. So yeah, that's the part that sucks the most about it, is that we all want him to get out, but we have to get him out on the legal grounds, which I think thankfully there's a really good shot at. I think a really good shot based on this appeal. So let's see, Charlemagne the God works for Desiree. Okay, yeah, that would make sense then. They pushed the lie that the appeal was already denied, which, yeah, that's just not true. Not true at all. But yeah, law does not run on sympathy. Yep, you're exactly right, which sucks. But Alexis saying, who does that help really? Being willfully ignorant and spreading that ignorance to your audience? I don't know, man. One of my favorite movies of all time is The Matrix, and one of the core themes of the movie is that ignorance is bliss, or at least ignorance can be bliss. And that's the whole premise of the villain who wants to go back into the Matrix and forget about the real world and just be ignorant and just enjoy his life. So a lot of people, yeah, ignorance is bliss for a lot of people, because sometimes the truth hurts and it's easier to just reject the truth. So yeah, it's unfortunate, but yeah, I just hate the machine that he's against. I'm praying the appellate court does the right thing. Yep. Yeah, fingers crossed. Looks like, yeah, we got 84 days, I think, until our deadline for that. Yeah. So we shall see. But anyway, okay. Well, 2.5 hours. Not too bad. Pretty quick and to the point, if you ask me. But for now, though, so yeah, like I said, I appreciate y'all being here. I'm not ending the stream. I'm still going to be here. But I'm going to do a little bit of switch up because, streaming, opportunity to do some new things, some different things. Basically, what I want to do on my streams is to talk about whatever high-profile cases we're following. Crystal said, I'll email you about it next week. I wish that mattered, but at this level, no. It would if it were in resentencing or on appeal. Yep. Yeah, no. Okay, I gotcha. But yeah, so basically where we're at is... we've got high-profile cases that I'm going to follow and give the updates as they come. Tory Lanez case, perfect example. If there's more out there that pop up that are interesting, then certainly covering those as well. But I've got some catch-up to do on this one, so that'll probably be our focus for our Sunday afternoons moving forward. So that'll be that. But beyond that, my plan is also just kind of share some stories that are happening throughout the week for me in my lawyer life, because I see some really crazy stuff, and I think it'd be fun to talk about a little bit, and really just have that be like kind of an open Q&A session with y'all. If you got any questions, I guess anything y'all got going on, or just want to talk about other cases or something involving you. I can't necessarily give legal advice if you're not a client, or I could get in trouble, but I'll do my best to, you know, share with y'all, have some good discussions about that. But on appeal, Crystal says, on appeal you can only speak about the record. That's why you do a writ to with an appeal. The writ was outside the record. It's procedure. Okay. Yeah. And Live Nation has a ton of lawsuits. Yeah, Live Nation has a ton of lawsuits. So, yeah, there are always going to be lawsuits and cases to cover. Heck, yeah, Demore Hadley against her mom in Rock Nation. That's a big one. The deposition that DJ Academics just did is that Megan versus Milagro Cooper? Is that lawsuit? I think. So that's another case I should probably look into. I'll probably get a lot of good stuff out of that. But yeah, beyond that, kind of as we get towards the end of the legal coverage, because I really don't want to spend too long on these Sundays. Really kind of like 3, maybe 4 hours is what I'm looking for. So I've been going 2.5 hours already. What's your email? Let me help you get your channels popping. Oh yeah, absolutely. So, yeah, you can hit me up, genzattorney@gmail.com. That's my email for this account, for this channel. Also, definitely, I think most of y'all already follow on X, but if you don't, be sure to get over there, x.com/thegenzattorney. I'm going to get back posting more regularly over there as well. And that'll kind of be our place to connect during the week, getting ready for the weekend stream. So, yeah. Lyrax is my manager. Yes. Self-appointed manager, I will say, but you know, I suppose. Meg Lawyer is asking about Drake and Nicki. Uh-oh. Yeah. Oh, Nicki Minaj. Maybe that's the next thing to do. Is Nicki Minaj. She went on quite the tirade, one could say. Quite the rampage across Twitter. But act deposition's like a 2-hour video. Oh yeah, we could definitely do that. Probably next week, I'll say. But yeah, for now though, I'd love if y'all stuck around. Basically, what I'm gonna do now, there is a video game called Ace Attorney, and if y'all didn't know, my profile image here is like a cartoon guy in a suit. That's the main character in Ace Attorney. His name is Phoenix Wright, and I've been using him as my profile photo, at least a buff version of him, really since I started the channel. But I've never actually played the game. So my plan now is to it's the first time ever live a real attorney plays an attorney video game. So my understanding, it's a crazy game. It's really funny. But hold on, let me click on this. Yeah, it's a really funny game. Got crazy stories. Lyrex, fake fan, has Phoenix Wright as his profile picture, but has never played the game. You know, you're right about that. So I'm righting that wrong. I'm going to, yeah, first time ever play Ace Attorney. So let me try and get this set up. Hold up. Alright. Uh-oh. You can hear it. Hold up. Oh, it's kind of loud. There we go. Okay. Don't want it too loud now. I know you can't see it yet, but I'm trying to get the screen to go full screen. Kind of too loud for me, actually. Hold up. Window mode. Here we go. Full screen. Beautiful. Okay. Oh! Hold up. Almost there. Bear with me. Okay, it's not going to be there. And then... Bam! We got it. But I think every time I click away... Yeah, I think every time I click away from the game, it minimizes stuff. I did this, yeah. If I ever adjust my... Oh, no. Hold up. It's embarrassing. Let me go back. Maybe I just do this. Can I make it bigger? No. Oh. How's this? Yeah. We don't need to hear you. It's fine. What do you mean? Yeah, Ace Attorney to declare obscure tomorrow. Great review. I learned a lot. I have to work now. God bless everyone. Free Tory. That's right. Thank you, KG. Thank you for being here. That's because you're full screen. You need windowed borderless. Oh, see? Alright. Maybe you can... Oh, wait. There is no window borderless. It's just windowed and full screen. My tech support. Lyrax. That works too. How's this? No, it still goes away. No, I'm just doing windowed. I'm gonna go big. Boom. Sean Hawley's daughter was a former backup singer for Beyonce. That's right too. Yeah. But okay. I think we're good. Backspace, back. Okay. Here we are. Phoenix Wright, Ace Attorney Trilogy. No idea what's gonna happen. Music in the background distracting. Of course. Okay. Keontae Lee, have a suggestion just for fun. You should come up with cases and have us argue them for fun in a segment of one of your streams when you get more acquainted. Okay, I can see that. Let's see. Well, maybe y'all get some good inspiration from Phoenix Wright. Ace Attorney Part 1. Oh, yeah. Probably going to play this for like an hour. Maybe like an hour or two. See how it goes. No idea if my real-life lawyer skills will benefit me at all. But we're about to find out. Uh-oh. It's murder. Thank you, Crystal. Thank you for being here. Yeah, we'll definitely be in touch. Yeah, well done again. Well done again in the argument. Uh-oh. Oh. But we already know who did it then. District Court. Here we go. Okay. Boy, am I nervous. Do I need to talk in a certain way? Get in my Phoenix Wright era? Maybe I'll talk like a 1950s newsboy. Boy, am I nervous. Right. Oh, no, sorry. Right. I'm sorry. I can't do the voice. Maybe just Phoenix. Oh, hiya, Chief. Glad I made it on time. Well, I have to say, Phoenix, I'm impressed. Not everyone takes on a murder trial right off the bat like this. Okay. Says a lot about you and your client as well. Thanks. Oh, sorry. Thanks. Actually, it's because I owe him a favor. A favor? You mean you knew the defendant before this case? Yes. Actually, I kind of owe my current job to him. He's one of the reasons I became an attorney. Okay. I just really want to help him. I owe him that much. It's over. My life, everything, it's all over. Is that your client screaming over there? Yeah, it's him. Death, despair. Oh! I'm gonna do it. I'm gonna die. Sounds like he wants to die. Yeah. But? Oh gosh. Nick. Is that my nickname? Nick short for Phoenix? Hey there, Larry. Dude, I'm so guilty. Oh no, I have to do my samurai. Oh, let me get this up a little bigger. Butts has a he's got a samurai like honor voice. Dude, I am so guilty. Tell them I'm guilty. Give me the death sentence. I ain't afraid to die. I commit seppuku. What? What's wrong, Larry? Oh, it's all over. I'm finished. Finished! I can't live in a world without her. I can't! Who took her away from me, Nick? Who did this? Oh, Nick, you gotta tell me. Who took my baby away? So, frame it on the husband, I see. Good strategy, so far, I can see. Person responsible for your girlfriend's death. The newspapers say, it was you! My name is Phoenix Wright. Here's the story. My first case is a fairly simple one. A young woman was killed in her apartment. The guy they arrested was the unlucky sap dating her. Larry Butts. My best friend since grade school. Our school had a saying, when something smells, it's usually the butts. Wow, I see what they did there. In the 23 years I've known him, it's usually been true. He has a knack for getting himself in trouble. One thing I can say, though, it's usually not his fault. He just has terrible luck. He's bad luck Butts. Oh my gosh. Bad luck Butts. But I know better than anyone that he's a good guy at heart. That and I owe him one, which is why I took the case, to clear his name. And that's just what I'm going to do. I believe. Oh boy, here we go. Here it is, chat, real time, real attorney plays this fake attorney. Gosh, if I lose this case, I feel like I just gotta shut it all down. I gotta hang it up. Court's now in session for the trial of Larry Butts. Prosecution is ready, Your Honor. I want to base my voice off of a coworker I used to work with. Prosecution is ready, Your Honor. The, defense is ready, Your Honor. Ahem, Mr. Wright. This is your first trial, is it not? Yes, Your Honor. I'm, a little nervous. Yeah, I get my bar license revoked if I fail this. Yeah. The pressure's on. The stakes are high. Your conduct during the trial. Now, let me get the judge. He's got a big beard, big manly guy. Let me give him a deep voice. Your conduct during this trial will decide the fate of your client. Murder is a serious charge. For your client's sake, I hope you can control your nerves. Thank you, Your Honor. Mr. Wright, given the circumstances, I think we should have a test to ascertain your readiness. Yes, Your Honor. Gosh, I'm falling apart. I thought I'd be a little more confident than this, but yeah. Oh, we'll create you a new logo if need be. Yeah, I'll need a new logo if I lose this case. How about that? Yeah, because at that point I will not be worthy of the moniker of the ace attorney, Phoenix Wright. But yeah, I'm a little too nervous for my liking. The test will consist of a few simple questions. Answer them clearly and concisely. Please state the name of the defendant in this case. Oh, I know this one. It's Bad Luck Butts. The defendant? Well, that's Larry Butts, Your Honor. Correct. Just keep your wits about you, and you'll do fine. Next question. This is a murder trial. Tell me, what's the victim's name? Do I know this one? I don't remember hearing this. Okay, now I'm nervous. Oh no. No, I don't. It was never told to me. I think I feel a migraine coming on. Uh-oh. Court record. Oh, okay. We're learning mechanics. Thank you. Attorney's badge. No one would believe I was a defense attorney if I didn't carry this. I feel that. Alright. Cindy. Okay. Let's do blunt force trauma. Can I actually read it? Cindy Stone, I see you. Look at those bangs. My gosh. Winston Payne, age 52, the prosecutor. Lacks presence. Generally bad at getting his points across. Where's my profile? Yeah, okay. Chief attorney at Fay & Co. My boss. And a very good defense attorney. Oh, so Mia's my boss. Okay. This is... Oh, now the pressure's really on. Okay, so Cindy Stone. I got it. Check it often. I can do that. Cinder Block. No, Cindy Stone. We got it. Oh, yeah. Oh, I know this one. Blunt object. Yep. Helps that we saw it happen in the opening. Correct. All right. Well, dang, I thought I was going to win the case based on answering those questions right. First, a question for the prosecution, Mr. Payne. Yes, Your Honor. As Mr. Wright just told us, the victim was struck with a blunt object. Would you explain to the court just what that object was? The murder weapon was this statue of the Thinker. Oh. It was found lying on the floor next to the victim. I see. The court accepts it into... What? Hello? Objection. I'd like to object. Where's the witness that is authenticating this exhibit? What exhibit is this? Are we marking this State's Exhibit 1? How are we establishing chain of custody here? When it was... You're saying it was seized from the scene. I need to know that it was kept secure in a bag, taken to the evidence locker. I need the documented chain of custody proving that this statue here of the Thinker was the same statue at the scene of the crime. Unbelievable. This judge is out to get me. He just accepted into evidence. Not even give me a chance to object. Unbelievable. Right. Be sure to pay attention to any evidence added during the trial. Okay. That evidence is the only ammunition you have in court. Not if I keep it out, you know, if they let me object, and it would have excluded the evidence. And then, boom. Yeah, it would not have come in, and I could have won the case because they would have had no case to present. But, you know, whatever. I'm over it. Okay. Let me see. I already know that. Okay. First witness. Whoa! You accepted an exhibit into evidence without even beginning the testimony phase of the trial to allow a witness to come testify? This judge, he's gone rogue. Oh my goodness. Prosecution calls the defendant to the stand. Hello? What about the right to remain silent? The right to be free from self-incrimination? The prosecution can't call my witness. I'm telling my witness, sit his butt down. He's not testifying to nothing. I can call him. State can't call him. Unbelievable. Chief, what do I do now? Pay attention. You don't want to miss any information that might help your client's case. You'll get your chance to respond to the prosecution later, so be ready. Let's just hope he doesn't say anything unfortunate. Uh-oh. Larry gets excited easily. This could be bad. Oh no, this is gonna be a disaster. Ahem, Mr. Betts. Is it not true that the victim had recently dumped you? Objection, leading. Can't lead a question. You can't lead a witness on direct examination. Hey, watch it, buddy. Wait, no, sorry. Hey, watch it, buddy. We were great together. We were Romeo and Juliet, Cleopatra and Mark Antony. Didn't they all die? I'm stressing. I wasn't dumped. She just wasn't taking my phone calls or seeing me, ever. What's it to you anyway? Mr. Betts, what you describe is generally what we mean by dumped. In fact, she had completely abandoned you and was seeing other men. Oh no. Oh, this is getting spicy already. She had just returned from overseas with one of them the day before the murder. What do you mean, one of them? Lies, all of it, lies. I don't believe a word of it. Your Honor, the victim's passport. According to this, she was in Paris until the day before she died. You know, I'll withhold my objection to authentication for now, for lack of foundation. You can't just hold something up and say it is what you say it is. No, you actually have to prove it is what you say it is. I'll let it slide for now, though. Indeed. She appears to have returned the day before the murder. Dude, no way. Victim was a model, but did not have a large income. It appears that she had several sugar daddies. The sugar daddies. Daddies? Sugar? Yes, older men who gave her money and gifts. Is there a question here, counsel? Are you planning on asking my client a question, or are you just planning on continuing to testify and say your piece? She took their money and used it to support her lifestyle. Dude. We can clearly see what kind of woman this Miss Stone was. Tell me, Mr. Butts, what do you think of her now? Here I am, defense attorney, sitting, praying. He's not going to say something like, well, I hate her now. I wish somebody would kill her. Please, no. Right. I don't think you wanted to answer that question. You're right. I do not. Yeah, Larry has a way of running his mouth in all the wrong directions. No, I'm gonna stop him. Yeah, not relevant. Boom. Got it. See, can I do it? Maybe a little more forward. That question is irrelevant to this case. Oh. Dude, Nick, what do you... I feel like Bad Luck Butts is actually, more like a surfer bro, so I'm gonna switch to that. Dude, Nick, what do you mean irrelevant? That cheating she-dog? I'm gonna die. I'm just gonna drop dead. Yeah, and when I meet her afterlife... Oh. Get to the bottom of this. Uh-oh. Uh-oh. I believe the accused's motive is clear to everyone. Yes, quite. Oh boy, this is not looking good. Next question. You went to the victim's apartment on the day of the murder, did you not? No. Well, did you or did you not? Heh. Heh heh heh. Well, maybe I did, and maybe I didn't. Uh-oh. He went, what do I do? Oh, man. Alright. Here's the problem. I don't know what he was doing there, because I don't remember having a conversation with him. So, if I had his story, yeah, I need to know why he was there before I know how to answer this question. I feel like it could only be bad. Well, no, I'm gonna stop him again. I'll send him. Oh no, I don't want to send him a signal. That's very improper. Lie like a dog? Well, see, it's like, I don't remember. You don't remember? Well then, we'll just have to remind you. I got a bad feeling about this. We have a witness that can prove he did go to the victim's apartment that day. Well, that simplifies matters. Who is your witness? The man who found the victim's body. Just before making the gruesome discovery, he saw the defendant fleeing the scene of the crime. Oh no. Is it the guy who killed her, though? Order. Order in the court. Mr. Payne, the prosecution may call its witness. Yes, Your Honor. On the day of the murder, my witness was selling newspapers at the victim's building. Please bring Mr. Frank's... Mr. Frank Sawit to the stand. Mr. Sawit, you sell newspaper subscriptions, is that correct? Uh-oh. I can see where this is going. It's going to be my time to shine, to break him down, make him cry, make him confess he is the killer. Oh, what voice does he have? Oh, I have no clue. We're just going normal. Oh, yeah. Oh, yes. Newspapers, yes. Mr. Sawit, you may proceed with your testimony. Please tell the court what you saw on the day of the murder. Witness testimony. Witness's account. Okay. Okay. Door-to-door selling subscription is when I saw a man fleeing an apartment. Thought he must be in a hurry because it left the door half open behind him. Thinking it strange, I looked inside the apartment. Then I saw her lying there, a woman, not moving. Dead. I quailed in fright and found myself unable to go inside. I thought to call the police immediately. However, the phone in her apartment wasn't working. I went to a nearby park and found a public phone. I remember the time exactly. It was 1 p.m. Oh, we gotta keep that in mind. Time is always gonna be important, or could be important. Yeah, let's keep that in mind. 1 p.m., chat. The man who ran was, without a doubt, the defendant, sitting right over there. Your Honor, I don't think you can just go into someone's house because you saw someone else leave the house. I mean, for law enforcement, yes, but he's not law enforcement. He's an innocent newspaper salesman, so he would not be bound by the Fourth Amendment in that regard. Larry, why didn't you tell the truth? Yeah, I can't defend you against testimony like that. Incidentally, why wasn't the phone in the victim's apartment working? Your Honor, at the time of the murder, there was a blackout in the building. Aren't phones supposed to work during a blackout? Yes, Your Honor. However, some cordless phones do not function normally. The phone that Mr. Sawit used was one of those. Okay. Your Honor, I have a record of the blackout for your perusal. Oh. Electricity to Miss Stone's building was out from noon to 6. Okay, so he's saying he was there at 1 p.m. There's supposedly a blackout noon to 6. Let's keep that in mind. Oh, Mr. Wright. Yes, yes, Your Honor. You may begin your cross-examination. Okay, I'm ready. What do you mean? What do you mean? Why am I confused? Oh no. Alright, that's it. Real deal. Supposed to cross-examine, ask him questions, impeach his credibility. Trip him up on the details. Yeah, expose the lies in the testimony. Lies! He is innocent. He must have lied in his testimony, that's right. Or is he really? Nope. He's not guilty. We're getting him off. How do I prove he's not? You hold the key. It's in the evidence. It's my first day and I didn't go to law school? Then how am I practicing? How did I get a law? How did I get an attorney's badge? Lyrax, thank you very much. No one would believe I was a defense attorney if I didn't have this. Okay. Oh, yes. The key is in the evidence. Time of death, 4 p.m. to 5 p.m. What he said, he was there at 1 p.m. Apparently our home Paris on 7:30, day before the murder. 7:31, died. Anything else? No, there's our first big impeachment point. You hold the key, it's in the evidence. Yep. There is. Once I found the contradicting evidence, present it and rub it in the witness's face. Could be like the guy on Suits. Yeah. He's got like a, not a photographic, eidetic memory. I think I watched the first episode of Suits and At the time, I was still a DA, and I'm like, nah, I don't like the civil stuff as much. I'll stick to my law and order criminal stuff. But now that I do civil stuff, maybe suits will be more interesting now. Okay. Oh, I already did. I already found the contradiction. You about to get exposed, bucko. What's this bar up in the top right? Yeah. Right. I'd like to see this guy's newspaper selling license. I don't think he actually sells newspapers. Can I go back? Phone apartment wasn't working. Yeah. Nearby park, public phone. Time exactly 1 p.m. That's all of it. Must be contradictory. I already got it. Okay, I appreciate running through it again for people who missed it. But I'm a real lawyer. I'm a real attorney playing ace attorney. I'm on it. I'm in there like swimwear. So, are we just going through it again? Let me get to the time. It's here. So, I just press Q, I guess? Hold it! 1 p.m.? Oh, I gotta do this. I gotta do it in the voice. 1 p.m.? Are you certain? Well, yes, absolutely. He seems really confident. 1 p.m.? Right. Doesn't that seem strange to you? Present some evidence to contradict him. Absolutely. Wait. So, can I do it now? Autopsy report. But I want to... Hold up. Sorry, this is probably user error at this point. I gotta get to the... Yeah. Line. Boom. Boom. Okay. Now I go tab, present, autopsy report. E, present. Objection! You found the body at 1 p.m., you're sure? Yes, it was 1 p.m. for certain. Uh-oh. Bang that table. Frankly, I find that hard to believe. You just came back from commercial break and they had to run through it again. I see, I see. Your statement directly contradicts the autopsy report. The autopsy notes the time of death at sometime after 4 p.m. There was nobody to, no body. Just like me in court for real. There was no body to find at 1 p.m. Uh-oh. How do you explain this 3-hour gap? Oh, now he's sweating. See, I got my stride. I banged the table one time. And I got this boy sweating. Oh, that? Oh, Why are you objecting? This is trivial. We just merely forgot the time. What do you mean? This is impeachment. Impeachment is always... Y'all have heard me say this before. Impeachment is always a question. Credibility is always a question whenever a witness testifies. Heck, Tory Lanez case, Megan Thee Stallion, her testimony, like, everyone's getting upset that, like, oh, everyone just needs to be nice to Meg. Why is everyone attacking her? It's like, well, it's because she testified, and her credibility is squarely an issue, which means, yeah, we're allowed to impeach her credibility and ask questions about it. So yeah, your objection is to be overruled. After testimony, I find that hard to believe. Mr. Saw It. Why were you so certain that you found the body at 1 p.m.? Gee, that's a really good question. Great job, right? Way to put him on the spot. That's all you have to do. Point out contradictions. Okay. Whole story falls apart. This is true. Wait, I remember now. Would you care to give your testimony again? Okay. Let's see what he cooks up for us. See, when I found the body, I heard the time. There was a voice saying the time. It was probably coming from the television. Oh, wait. But what about the blackout? Oh, but it wasn't 3 hours off, was it? I guess the victim must have been watching a video of a taped program. That's why I thought it was 1 p.m. Terribly sorry about the misunderstanding. Sorry, buddy. I see. You heard a voice saying the time on the tape program. Mr. Wright, you may cross-examine the witness. Oh, I got it. I already know what to do. Yeah, I know what to do. She's right. I've got this one. Time of discovery. Give me the... It's probably coming from television. Can I... I'm not even... let me. Do I want to press him first, or do I? Oh, let me just go straight for the evidence. Electricity showing the blackout. Present. That's right. Yeah, spank that paper. This record proves it. Spank that table. You couldn't have heard a television or a video. Uh-oh. Gah, irk. The defense has a point. Do you have an explanation for this, Mr. Sawit? No, I find it quite puzzling myself. Quite. Wait, I remember now. Mr. Sawit? The court would prefer to hear an accurate testimony from the very beginning. These constant corrections are harming your credibility. Gosh, he's just like Megan Thee Stallion, for real. Changing testimony on the stand, getting caught in lies, man. That, and you seem rather distraught. Yep. We're on to you. My apologies, Your Honor. It must have been the shock of finding the body. Very well, Mr. Sawit. Let's hear your testimony once more, please. Alright, let's see. Hearing the time. Actually, I didn't hear the time. I saw it. There was a table clock in the apartment. There was a table clock in the apartment, wasn't there? Yeah, the murder weapon. The killer used it to hit the victim. Oh, you mean the statue? Please, this is child's play. Yeah, Jamie, Zach, you're right. Spank that like button. If you're here, you haven't hit it yet, go ahead. You saw a clock? I guess that would explain it. Defense may cross-examine the witness. So, yeah, no. If he's saying the clock is the murder weapon, I mean, we all know that. That's just not true. It's the statue. I saw it. There's a table clock in the apartment. Wasn't there? Yeah, the murder weapon. Use a kill. Let me press him first. Let's see what happens. The murder weapon? Yes, the table clock was used as a weapon. So, another great trial court lawyer practice tip. If you've got a witness that you've just caught in a lie, it is good practice. Get them to double down. Get them to establish this is absolutely what I believe. So perfectly, this is a good example here. I'm getting him to, I'm asking very specifically, very clearly for everyone to hear, you're absolutely positive you saw that. No misunderstanding, no confusion. And that way, when you hit him with the contradiction, hit him with the evidence that proves he's lying, it hits even harder because now you just reminded everybody of what his position is. Something's fishy here. Absolutely. Alright. Get there. Table clock department. Wasn't there. Murder weapon. Present. Statue. Present. It was his statue. Yep. How is this supposed to be a clock? Great point. How is that supposed to be a clock? You, with your objections and your objections in your evidence. Just who do you think you are? I'm an ace attorney. That's who I think I am. Oh, good. Don't get caught. Don't get baited into it. Circle back. Just answer the question. Hey, I saw it there. Okay, that's a clock. Your Honor, if I may. Yes, Mr. Payne. As the witness stated, the statue is indeed a clock. No way. The neck is a switch. You just tilt it and it says the time out loud. As it doesn't look like a clock, I submitted it as a statue. My apologies. Can we examine this exhibit, please? This is a clock. Okay. I still say yes. Yeah, and he said it was gone. Boom. Clearly, contradiction. The witness knew it was a clock because he... Oh! I see how we're getting there. He knew it was a clock because he went into the apartment. You were inside the apartment on the day of the murder. Oh yeah? Prove it. Prove I went in there. I'll do better than that. I can prove you were the one who killed her. You struck her with the clock, and the shock of the blow triggered the clock's voice. That was the sound you heard. Uh-oh. Uh-oh. Okay. Yes, Your Honor. Mr. Solid, the sound must have left quite an impression on you. Understandable, since the murder weapon spoke just as you hit the victim. That voice was burned into your mind. That's why you were so certain about the time. Oh, he actually sounds like how I'm making him out to be. Y'all heard that? Objection! What was the meaning of this? This is all baseless conjecture. No, 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 not conjecture at all, good sir. Baseless? Just look at the witness's face. Yeah, he looks a little guilty. Would the witness care to elaborate? Did you strike the victim with the clock? That day, I never, look, the clock, I heard, no, I mean, I saw, Gua. Oh. Wow. That was a turn. Bold decision. It was him, I tell you, I saw him. He killed her and he should burn. Burn, give him death. He's a witch. She's a witch. Burn her. Exposed. Your Honor, a moment, please. There isn't a shred of evidence supporting the defense's claims. Mr. Wright. Yes, Your Honor. You claim the sound the witness heard came from the clock. Do you have any evidence? The whole case is riding on this. I better think it through carefully. Uh-oh. It's my moment. Heard was definitely this clock. In fact, so this must be like my life bar. If I get it wrong, that's what I lose. Clear if you... Yeah, let's try sounding it, right? Yeah. Oh. If the clock don't fit... No. If the clock don't spit, you must acquit. More like if the clock do spit. The time, that is. May I have the clock? Oh, this is dramatic. Here we go. That is... Well, he is the thinker, after all. So we've heard the clock. What are your conclusions, Mr. Wright? Mr. Payne, can you tell me what time it is now? 11:25. Oh, 3 hours off. Boom. The clock did spit. Now you must acquit. I need to put that on a shirt. Exactly 3 hours slow. Precisely the discrepancy between what Mr. Solid heard and the actual time of death. Never heard that one before. Yep, that's a Scotty O Gen Z attorney exclusive right there. If the clock do spit, you must acquit. So, Mr. Solid, try to talk your way out of this one. I agree, Lyrax. Mr. Solid, more like Mr. Dunnit. Ha ha. You forgot one thing. Oh, don't tell me he's got like a gun. Well, it may seem like that clock is running 3 hours slow. It proves nothing! How do you know it was running 3 hours slow? On the day of the murder. Okay, fair point. Fair point. You can't prove that you don't have a case. I think I still have a case. If I can't prove that. But, you know. He's right. How am I going to prove that? Hey, stop sweating. We got this. Damn it, I was so close. Mr. Wright, it seems you lack the critical evidence to support your claim. Yes, Your Honor. This means I cannot let you indict the witness. Wait, me indict? I'm not the prosecutor, though. That's got to be the other guy. Unfortunately, this ends the cross-examination of Mr. Frank Solid. I come all the way down here to testify, and look what happens. You treat me like a criminal! A criminal! You lawyers are all slime. Grr, I almost had him. Sorry, Larry, I failed you. Still, this should be more than enough for not guilty. Like, what's wrong? What's wrong with that? Uh-oh. Not so fast, Mr. Solid. What's Mia got? Listen up, right? Don't throw this one away. Not like this. Think. But Chief, it's over. I can't prove the clock was slow the day of the murder. Nobody can prove that. Well, yes. Out of the box. Maybe... Well... I don't know if the blackout has anything to do with it, because this was working independently of the blackout. I'm thinking maybe it's... I recall... Yeah. I'm thinking... Why was Clock 3 hours slow? Or maybe it is the blackout. No, because it said 1 p.m. It was used at 4 p.m. The blackout started at noon, so that's 4 hours, not 3. Right. Right. 3 hours slow. I'll say yes because I guess I have to think. Maybe wait a second. I think I might have it. I might have brain blasted for a second. Maybe I can prove it. Yeah. Because it's rather heavy. And apparently arrived home Paris 7:30, day before the murder. Maybe, I'm thinking maybe Paris is a different time zone. Did she get the statue from Paris and it's 3 hours off? That might be the son's body. So likely seen. Either that or maybe the blackout just threw the time off enough. All remembering slow on the day of the murder. Have you found evidence to support this claim? Of course. There's a piece of evidence in the court record that can prove my claim beyond a doubt. feel like it's got to be the passport, just because I haven't used it yet. I've used everything else. And I just don't see how it could be anything else. I don't really see how it could be the passport, but I feel like we're about to get some explanation. I don't know. Let's rock with it, see what happens. Home from abroad the day before the murder. Oh, okay, okay. Yep. I mean, yeah, I knew that. Brain blasted that. Yeah, easy peasy. Clock wasn't 3 hours slow. It was 9 hours fast. Yeah. Got him. Boom. Mr. Saw, or should I say, Mr. Did It. Oh, Lyrex exposed. Thought you had an original funny joke back there. Ripped off from the game itself. Order! Well, this case has certainly turned out differently than we all expected. Mr. Payne, your witness. He was arrested and has been taken away, Your Honor. Very well, Mr. Wright. Yes, Your Honor. I have to say, I'm impressed. Oh, sorry. I have to say, I'm impressed. I don't think I've ever seen someone complete a defense so quickly. And find the true culprit at the same time. Thank you, Your Honor. At this point, this is only a formality, but this court finds the defendant, Mr. Larry Butts, not guilty! Yeah! Okay, I get to keep my law license. This court is adjourned. Frank saw it was a common burglar. Check to see when people were out of the house. That day. Uh-oh. Victim... What? When Larry went there, the victim wasn't home. After he left, Mr. Salt let himself in to do his dirty work. A common cat burglar. Victim returned. Flustered, Mr. Salt grabbed the nearest blunt object he could find. Dang, man. Heck yeah. I can believe he won. Never had a doubt. Not at all, not at all. You fought your own battles in there. Yeah, I did. You're right about that. Ooh, potential love interest? Maybe? That's right. No, real potential love interest right here. My life is over. Why? Dead and gone soon. Uh-oh. Good. Wait, no. I mean, bad. Bad, bad, bad. Larry, you're innocent. The case is closed. But my Cindy Wendy's gone, man. Gone forever. Sorry, buddy. Yeah, let's just comfort him, not bring up Cindy's tendencies, we'll say. Harry? Who's Harry? You mean Larry? I thought it was Larry Butts. Hold up. I gotta check this. Yeah, it is Larry, not Harry. Definitely not Gary or Terry. Really owe you one. I won't forget this, ever. Stop sweating. You're free, man. Let's celebrate dinner, movie. Oh. Wow. I thought they both were my love interest. But alas, I was duped. Oh no, I couldn't. Hey, I was the one who got you off the hook. Oh, hey. Here, take this. It's a present. The murder weapon? How thoughtful. Aww. Actually, I made this clock for her. Made one for her and one for me. Oh, so he's got one left over. Yo, Nick. Wow. Yes, she was. Yes, she was. Excuse me? I think she thought quite a lot of you, in her own way. Nah, you don't gotta sympathize with me. It's okay. Oh, I'm not just sympathizing, really. Isn't that right? Right? She likes saying right. Don't you have something to show your friend? Something that proves how she felt about him? Huh? Oh, yeah, right. What the heck is she talking about? Do I give him her autopsy report? I think that might show how much she loved him. I guess it's probably the statue, right? Yeah, she kept it. Yeah. Aww. Yeah. Yeah, I'll give him my attorney badge. I actually got my attorney badge. Right in here. Boom. I'm gonna hold it far away. I don't want to see my details, but right there. Also got a knife. Woo! Oh, sorry. I don't know if that's against terms of service. Eh. Hopefully not. Well, make of that what you will. Hey, Nick. I'm glad I asked you to be my lawyer. Really, I am. Thanks. Hope that made him feel a little better. Heck yeah. Right? I hope you see the importance of evidence now. Also, hopefully you realize things change depending on how you look at them. People, too. We never really know if our clients are guilty or innocent. All we can do is believe in them. Do you believe in love after love? In order to believe in them, you have to believe in yourself. Oh, I'm so moved. Right. Listen, learn, grow strong. Never let go of what you believe in. Never. Well, I think our work here is done. Shall we be off? Yeah, I guess so. Say, how about dinner? On me. Oh. Okay. We'll drink a toast to innocent butts. Dang, his first name just keeps changing, huh? Yeah. Oh, speaking of Harry. You were saying part of why you became a lawyer was because of him. Yeah, part at least. You have to tell me more about it sometime. Maybe over drinks? Oh, this is very improper. Very unprofessional. Actually, there are rules of ethics that exist to stand against improper relations between attorneys. Especially a supervising attorney and their underling, which is what we are here. And so, my first trial came to a close. Larry slapped me on the back and said, "Gee, Nick, it's good to have friends. But I'm pretty sure he's not going to pay us. Unless you count the clock he gave me. I didn't know it then. But that clock was soon going to be at the center of another incident. Oh, great. And my promise to tell the chief about me and Larry would be one promise that I wouldn't be able to keep. Uh-oh. That's what we call foreshadowing. Oh, sorry. The end. Heck yeah. Clear clear episode 1. A brand new episode has been added. Oh my gosh. Look how flashy. Wow. Alright. Well, I'm gonna leave it to y'all then. I could do I could do one more. Or I could call it at that point. I'm kinda hungry, so definitely gonna eat afterwards. Let me try this out. Let me make a poll. Yeah, let's see. One more or nah? I'll say one more case because it's a yes or no question. So, all right, poll in the chat. It's there. Let me know what y'all think. Oh, I already know who voted that. Who was that? One vote for yes. Or, I guess, oh, 2 votes. I'm gonna give y'all like 1 minute to vote. Wow, oh, wow, okay, 3 for yes, okay. I feel like I know who 2 of them are, though, and I don't know if I should count those. Let's see. We don't care about your hunger. Ugh! I've been staying hydrated, you know, with my let's taco about fitness. It's just been a very punny day. All right, if I get to 5 votes for yes, I've got 4 right now. And I have a feeling number 5 is coming. And there it is. 5. My gosh. Why do I do this to myself? Alright. 1 more it is. Ending the poll. Yes. Save. Yeah. So too, the Turnabout Sisters. Oh, there's an investigation. Now, okay, let me continue. 1 was me, even though I'm going to drink my hot chocolate. You know, understandable. We just went to Cracker Barrel last week, and with a volleyball, I'm a coach for a volleyball team, and one of the girls got a hot chocolate there. And when I tell you, that was like the biggest hot chocolate in like this giant mug, and had whipped cream, like pyramid on top. It actually looked delicious. I was very jealous. Hello, this is Maya. Hey Maya, it's me, Mia. Mia and Maya, uh-oh. Haven't called in a while. Sorry, I've been so busy. How have you been? Well, lonely. And it's all your fault. Uh-oh. Nah, I'm just teasing. I've been great. Good, good. I'm finally getting used to having my own place. That's good to hear. Actually, I'm calling because I have a favor to ask. I know. You want me to hold evidence for you. Sharp as always. Oh. Now why? How do you feel that Cracker Barrel redesign? Go woke, go broke. That's what. No, I'm just kidding. I mean, I feel like that's just been the standard for all these companies. Rebranding to minimalism. What's the saying? Minimalism is a scam by big small to sell more or less. I think that's the saying, right? Yeah. So they're all going for this minimalist design, and so I'm not surprised. However, I do hope they revert back, because yeah, maybe Trump needs to declare the Cracker Barrel logo, the Cracker Barrel trademark, as an American historical property, and therefore no one's allowed to change it. I'd be in favor of that. Sharp as always. There's a lot of buzz about the upcoming trial. I just don't feel safe keeping the evidence here. I gotcha. So what is it this time? It's a clock. Oh? Clock? Statue. The Thinker. It tells you the time. Uh-oh. I see we're tying in the last case. Thought you might like it. You always like toys. Hey, I'm not a little girl anymore, sis. Now, you know I'm only teasing. Ah, I should probably tell you, the clock isn't talking right now. Huh? It's not working? That's lame. I had to take the clockwork out. Sorry. Put some papers inside it instead. Papers? Is that the evidence then? Well, there's a possibility that it might turn out that way, yes. Can you come by the office tonight, say 9, to pick it up? I'll be in a pretrial meeting until then. Okay, sis, but I expect dinner, something good. Like, burgers. I could really go for, oh. This is not helping my hunger right now, and I was already thinking about swinging through like, well, it was the fact that I'm already hungry, and then I started talking about minimalist brand redesigns, and I started thinking about Burger King and their new logo, and it made me think, man, I could really go for a Whopper. And now here we are talking about burgers. Ugh. You torture me. Okay. We'll hit the usual joint. All right, it's a deal. Okay, sis. See you soon. Yep, I'll be waiting, Maya. Okay. Conversation recorded September 5th. Okay. Now, Miss Faye, I'll take what's mine. The papers. Uh-oh. Can't give you what I don't have, true? You are a poor liar. Why, I see it right over there. That must be the thinker that swallowed those papers. How could you know? Ho ho. You are not cogniferous of my background? Gathering information is my business, you see. I should have been more careful. Ho ho ho. Is this Santa Claus? That would explain. It would explain the ho-hos, and it would explain how he knows everything, because Santa is spying on us. My dear Miss Faye, I'm so very sorry. But I'm afraid I must ask you for one more thing. Your eternal silence. Farewell, Miss Faye. Oh. Is she actually about to die? Oh, wow. Red, white, blue. Did they just kill our boss? We didn't even get a chance at love. It's so sad. Uh-oh, I'm late. We should all go out for dinner. What's that smell? Blood! Oh, Mia! Yeah, I've got to go examine. I smell... Oh, how do I do this? Oh, so I move first. Yeah, move into the office. Someone's there. Oh no. Chief. What? Dropped out cold. I left her lying on the office sofa. I went back to see where she lay under the window. Okay. Her body was still warm. I could feel it when I held her shoulder. Then, all too quickly, it began to fade, until finally she was cold. Dang it! But maybe... No, never mind. Chief. Alright. So if I move... No, nothing out there. So back, examine. Yep. Are there any clues here? She was struck on the head with a blunt object. She probably died instantly. The thinker must have been the murder weapon. Okay. Glass shards. Glass light stand lying broken in the back of the room. Okay. Broken beyond all recognition. Piece of paper. I don't know. What could it be? A scrap of paper. Maya? That's what I'm thinking. I'm sus of the sister, Mia. Or no, Maya. Blood on the back. Oh, so sad. That's gotta be the sister, right? Photo Q. Funny. Uh-oh. Oh, great. Am I about to get framed? I gotta defend myself? I mean... The gate water, nice. Not the water gate, the gate water. Anything else? What is... Oh, the thinker. I already got that. The ledger book. Small office, but it makes a good bit of money. Mia the culprit for sure. Well, no, I think Mia's the victim here. I think, right? Finally, the chief was never good with machines. Am I not supposed to be doing anything? Move. Let's move. Yeah. Uh-oh. But we saw who did it. That's, I'll say I don't like that about both cases so far. I don't like the fact that it showed me who did it. Like, I like to figure that out for myself, you know? Don't scare me like that. Excuse me, but who are you? It's okay, I work here. Maya Fey. Yep. So why is your name written in blood on a shopping receipt? Let me talk to her first. What happened? Excuse me, can you tell me what happened? Came in, the room was dark, and sis, she was already dead. The chief's sister. I'm her younger sister. You were here visiting this late at night? Yes, she said she wanted me to keep some evidence for her. Evidence? Yes, it was that clock. The thinker. I don't think there's any more examining that needs to happen. I guess let me present her with my attorney badge. No, just kidding. On the back of this receipt. That's my name. Why? Why would she write my name? Just calm down. Why would sis write my name? Oh, 1 second. I just realized my stream name is still Tory Lanez Appeal Breakdown. Let me change that real quick. Boom. First stream ever. Save. Cool. Alright. Wee woo wee woo. The police! They're coming this way. Freeze, police! Ah. Gumshoe. Must be a detective. Yeah, there we go. I'm Detective Dick Gumshoe. See? Gumshoe? What an odd name. Got a person say they saw a murder. This is true. Want either of you moving 1 inch, K? Whoa! Excuse me. Eek. This word Maya here mean anything to you? That's my name. What? I mean, maybe. Well, now I know it's not her. Well, we already know it's not her because they showed who it was. Mia's younger sister Maya was arrested on the spot. I was taken in for questioning and didn't get out until the morning. My eyes were heavy, but I couldn't sleep. Sat around, waiting for visiting hours to begin at the detention center. Had to talk to Maya as soon as possible. Wow, they have poor Maya locked up like a criminal! I mean, that is what happens when you're suspected of murder. The lawyer. Good morning. Are you in need of my legal services? I'll say it's up to you. Because certainly it's a bit odd representing her. She's accused of killing my boss. So I don't want to assert it myself, but I also don't want to say no. So I will let the client make the call. Yep. This is true. Yeah, you did. It's okay, I understand. And I've also heard about you. Heard? Heard what about me? I was talking to my sister on the phone the other day. Today is my junior partner's first time in court, and I won a murder trial, that's right. Quite the scene. It's been a while. What do you mean it's been a while? You're 27. So he crashed and burned? He's a genius! I mean, yes, this is true. One of those strike fear into the hearts of evil types. Only thing he's lacking is experience. Yeah, I don't know, Maya. I think you might want to wait. Give him 3 more years. Uh-oh. She's going to say no. Unless you want to be found guilty. Uh-oh. She's not going to hire me. She said, oh. ... I'm sorry. I didn't mean to insult you. No, it's okay. It's true, I guess. But at the same time, I can't just sit by and watch. When I think of the person who did this to Mia. I know. Something I've been wanting to ask you. Yes, what's with that outfit? Oh, this? This is what all acolytes wear. Acolyte? Acolyte of what? A spirit medium. Uh-oh. I have a feeling I know where this is going. Day of the murder. Yes. Let's see. That morning. Got a call from my sister. Showing me to hold on to a piece of evidence for an upcoming trial. Evidence? Yes. That clock shaped like the thinker. That one that Larry made. How could that have been evidence in a case? Right. She said something about that. I remember. You want to hear it in her own voice? Her own voice. Conversations on my cell phone. Recorded it. Oh, okay, okay. Sister, on your cell phone? Let's hear it. The detective took my cell phone. Let's see, don't forget. Sure, thanks. Conversation I had with my sister was recorded on my cell phone. Yep. Medium in training. So are we gonna converse with Mia through the spirit realm and have her identify the killer? She'll testify in court as a ghost, maybe? Very sensitive to the spirit world. Fae families. Mia was into this stuff too? Of course. She left the mountain to follow her career, she said. Her powers were first class too. Or maybe she was able to remove her spirit from her body to preserve herself. She just has to find a new body to take over. And then Mia will be back as a character. ESP and all that? Yep, yep. In training. Can't you contact Mia's spirit? Oh, that's what I said. Ask her who killed her. I was wondering, could I ask you a favor? Famous lawyer. My sister gave this a long time ago. You are in trouble. What if I figured I would let her make the decision on who she wanted, and then she would say, of course I want you. Then cool, we're good to go. But then she was like, no, I don't. So it's like, I want to represent her, but I feel like if I do this, it's going to lock her into another lawyer. But it is her wish. I will respect the wish of the client. Let's turn to... Say, what about your parents? Uh-oh. It's a lot of dots right there. I see. Don't worry. Leave it to me. Thank you. Trial's tomorrow at 10. Tomorrow? What if this guy refuses? They told me that if I don't find one, the state will pick an attorney to defend me. When will that happen? Giving me until 4 this afternoon. Visiting hours are almost up. I'd better hurry. Okay. Let's move. Grossberg. Very lawyerly name. Big Boss is out! Couldn't say when he'd be back. Must be hard to keep track of everything when you're a famous lawyer. True. Not to mention run an office like this. I guess I'll just have to come back later. So... anything? Police officers all busy searching for clues. Hey, is it Gumshoe? Yeah, Gumshoe. I need her phone back. That Butts guy? No, I'm not. Phoenix Wright. How can anyone mistake me for Larry? He was a killer, and you're no killer. Mr. Butts was, yeah, he was acquitted, not guilty. And you were Detective Gumshoe. Hang on. That's Detective Gumshoe to you. Anyway, get that name right. Don't go calling me Dick. Hey, Dick, get over here. Yes, sir. The lawyer, right, pal? If you got business here, you better do it quick. Thinks I'm Maya's lawyer. For the trial. Sorry, pal. This is one trial you aren't going to win. Say that. The city's put Prosecutor Edgeworth on the prosecution. That's not... oh, yeah, that's not the same one. We got a new one. Edgeworth. sure you know what that means, you being a lawyer and all. What does that mean? That's right, pal. Mr. Miles Edgeworth himself. Wait, you do know him, don't you? Of course I do. He's a feared prosecutor. He doesn't feel pain. He doesn't feel remorse. He won't stop it until he gets his guilty verdict. Well, I'm talking about him that way. You make him barely sound human. Still, I'm afraid this pretty much decides the case. So Edgeworth is on this one. He hasn't lost a case since he became a prosecutor at the incredibly young age of 20. Well, there's a first time for everything, Miles. Back alley deals and forge evidence. Uh-oh. He hates crime with an almost abnormal passion. Facing him so soon. Anything about Mia? Is this guy bipolar? Okay, 9 p.m. Okay. I want to present him with anything. Yeah. Maybe get his cell phone back. I mean, sure. I mean, wait a second, pal. Tricky lawyer. I'll tell him straight. I'll be honest. Tell him why I want it. There's no way he'll give it to me. Something the matter? Oh no, it's just, you know, detective. Nope, I know nothing, pal. Cell phone has a lot of numbers on it, like her boyfriend's. Cell phone holds all the little girl's sweetest and spiciest secrets. Oh? You're trying to confuse me. Sorry, pal. I already checked all the numbers in memory. Impressive. You're quite the detective. Uh-huh. Oh, here, you can have the phone back. No suspicious call records. Okay. Chief and Maya. Okay. I'll be heading out now. The caller? Yeah, what did she see? April, May. Nice. Can't really tell you anything about her. You did just tell her your name. The lawyerly tricks. Alright. Let's move to the Gatewater. Oh wow. Ooh woo. Oh, that is smooth, right? Real smooth. Yes, let's examine. What is this? Screwdriver. Bad boy. I don't know. What about this? Yeah. Is it the real culprit? Nothing there from the... Yes, let's talk about what you witnessed. What did you observe? Oh, observe. Incident. You sound just like a lawyer in the movies. I like a man with a big vocabulary. Go. Better not encourage her. Oh. Hi, I'm single, ready to mingle. Oh, not me, but Phoenix Wright is single, ready to mingle. Alright, you know the thing that occurred happened the other day, the bad thing? What did you see? When it happened? I don't suppose you could tell me about it. Pretty please? Let me see. Well, dream on! If you want to know, just have to come to court tomorrow, Mr. Lawyer. She obviously watches a lot of television. In the garbage. Who exactly are you? Are you hitting on me? A very fruitful conversation. Do you want to present her with anything? No. Alright. Let's move. Let's see if he's back yet. Bigwig lawyer. Oh? See here. Aha! Hello. Hello, fellow lawyer man. Not particularly busy. Marvin Grossberg. Quite busy here, son. I can't go take a case on a day's notice. No, it's quite impossible. Wait a second. How'd you know the trial was tomorrow? Good point. Ah. Nah. Well, no. He obviously knows something that he's not letting on. Worked here a long time ago. A mission? What about that painting? Color of the sky, the hue of sea, the leaves, huh? Oh. Jeez. Yes. I'm busy, you see, but the client is Mia Faye's sister. However, sorry, but I must refuse. Sorry, goodbye. Creep. Fine. Anyway, I'll go look elsewhere. Think not. Uh-oh. Did you say something? I think not, I said. What do you mean? I'm terribly, terribly sorry. So we'll take on this particular case. Terribly sorry, my boy. I cannot say. Did the fancy man at the beginning, he's got connections. Alright. Well, let's go break the news. Looks like it's me and you, Maya. I'm the lawyer. Well, see, just be honest. I think I should use that guy. He didn't seem healthy. He was all skin and bones. Okay. What really happened? You don't mean he refused? I see. I've been abandoned then. It's okay. What about your family? Okay. Medium generation. Sorry, I'm speed running at this point. This one's taking a lot more time than the first case. So I guess after that, my sister announced she would become a lawyer. And she left the mountain. So you live by yourself. Yes, I've gotten used to it. Oh, also, I had to become independent. I-N-D-E-P-E-N-D-E-N-T. Do you know what that means? Sorry, that's my new catchphrase. Whenever I see the word independent. Mother's enemy. 15 years ago, it was an unusual murder case. Made quite a stir. Everyone was talking about it, apparently. Police were running out of leads, and they were getting desperate. The spirit meeting, did they? Case was solved, we thought. He was innocent. Ah! Yeah. Nation, I see. Right, that was his name. No, I'll defend you, Maya. Yes. Well, I don't know why. Yeah, I'll go with they can't abandon you. Aww. That's right. It's so true. I won't abandon you. You can count on me. Yeah. Great point. Okay. Kind of gotten used to it. Let's see. That morning I got a call from the sister. Wanted me to hold on a piece of evidence for upcoming trial. Finger clock. Probably qualified as a serial murderer by now. When did you arrive at the office? Right around 9. Ooh, that's like, I think that's when time of death is estimated. All right. I want to get in there. Let me see if I can get in. Oh, hello. Beg your pardon, the bellboy. Oh. Currently using the facilities. Oh, so I have time. Yes, get out of my way. That's right. Oh, I almost forgot. You came back quick. There's a message for her. That Mr. White of Blue Corp phoned. Oh, I know a Mr. White. Yep. All right. What is in here? Oh. Oh. So she listened in on the phone call to get the intel. So then her buddy could go get it. Go get the papers. I'll get to this one bottom. I mean, you know what I mean. Oh, bellboy. The tangoing with you tomorrow, Miss May. Yeah, let's get to court. Oh, to be continued. Yeah, save. All right, here we go. September 7th, we're in court. I get to meet Miles Edgeworth. All right. Let's get it. Let's win this case, and we can all go home happy. Prosecution is ready, Your Honor. The defense is ready, Your Honor. Miles Edgeworth. Better show any signs of weakness. Oh, I got him. I ain't scared at all. Scene of the crime. Prosecution has evidence she committed this murder. And we have a witness who saw her do it. Prosecution sees no reason to doubt the facts of this case. What? I don't get to give an opening statement? What the heck? Man. Question calls chief officer at the scene, Detective Gumshoe. My boy. It should be interesting. Detective Gumshoe. This is floor map of the office to explain. Okay. Oh, what a nice shape there that is. Floor plans, okay. Yes, why did we arrest Maya? Hard evidence. Boom, here we go. I rushed to the scene. 2 people there already. The defendant, Miss Maya Fey, and the lawyer, Mr. Phoenix Wright. Okay. We saw Miss Maya Fey at the very moment of the murder. Okay. Yeah. What's this? Okay. Something wrong. Oh, okay, okay. Try and trip him up with some details. Let's do it then. Here we go. As soon as the phone call came, you rushed to the scene. Oh, really? You rushed? Are you a football player rushing the passer? Not sure it did much, though. Right, please continue. People there already. Oh yeah? 2 people? Unlucky for you, I can't count. Three minutes. Wow. Indeed. Hold it! Oh, hit the table now. The shirt with her funky hippie clothes and your spiky hair. Oh. Oh, wow. Well, we only stand out like suspicious people at a crime scene, which means by definition we are not suspicious people at a crime scene. We only look like them. Immediately arrested. Okay, let me. Yeah. True. Yeah. Sorry, I got the order things mixed up in my testimony, Your Honor. There was something I should have told you about first, Your Honor. Very well, Detective. Let's hear your testimony again. Uh-oh. Let's hear it. After securing the suspect, I examined the scene of the crime with my own eyes. Found a memo written on a piece of paper next to the victim's body. Oh, yes, yes, yes. Victim's blood. Order in the court. There's my hard evidence. Why didn't you testify about the vital piece of evidence the first time? I know. I'm real embarrassed I'll forget about it. Try to be more careful. Very well. Defense may begin cross-examination. Alright. See with my own eyes. What was the victims? Let me press on that. Wrote the killer's name. I'll press on that. How do you know? She is the killer. I'm in the books and movies. Isn't a movie. Oof. Let's talk about reality, shall we? I guess. I haven't heard of many cases, no. Don't you find it a little odd that the victim would write down a name, especially the name of her own sister? Yeah, actually, you got a point, pal. Objection. Stop right there! The witness's opinion on the matter is irrelevant. The facts are clear. The victim wrote down the name of the accused. The victim told us the name of her killer. That didn't go so well. That's right, what he said. It's his whole testimony. Okay. Contradiction in there somewhere. Let's see. Was it after, though? I'm pretty sure he saw it right away. Got a memo written on a piece of paper. Let me save the wiretap for Miss May. Oh! Her name is April May. Who's to say this is not saying May with a little something that looks like an A in the end, but is not, because all she's trying to say is May? Maybe. Alright. They aren't, are they? Oh! Dang. Okay. Okay. Memo written on a piece of paper next to the victim's body. Oh, then who did write it, smarty pants? Let's say it. The killer. Is framed. Oh, and if that's the case, where's your evidence? Bit of a tall order for you. Those evidence shouldn't open their mouths, Mr. Wright. Ah. Maya was written clearly in blood. How do we know it actually says Maya? Hold it. I hear they take the little bits in the blood. Oh yes, I should have actually caught this. Because yeah, how could he testify to the veracity of the lab test? Yeah, you need the lab analyst to come in and do that. That's right. Where was I? Oh, I already did this. Alright. This whole testimony. Dang. I feel like I already went through all of them. I think I missed one, but I can't remember which one. My eyes written clearly in blood. I mean... Alright, I just gotta go through each of them. Hold on, witness was in our hotel room at the office. Maybe, yeah, just say it was me. That's the only thing I haven't tried yet. I did. It could have been me. So it was you. No, I'm just saying it could have been me. Can you prove it wasn't? Hold on, so you admit to this. You admit that you wrote that note? Listen to me, Mr. Wright. This is a court of law, and I expect you to refrain from making thoughtless statements. Amateur. Oh! Alright, I just gotta keep going through. I've already gone through everything. Hold a conversation between the chief and Maya. I feel like I'm stuck. I pressed him on every point. I don't know. I don't know, man. I'm open to suggestions. Let me see. Yeah, I don't know. I'm confused. Autopsy report. Wrote this note that she was accusing the defendant. Oh yeah, okay, so how... Autopsy says she died instantly. Yeah, shake that head. See, I was confused because I felt like I had to introduce the thing based on a specific thing that he was saying. But I guess I could have just introduced it at any point. Died immediately. I got it. day after. The execution's point being, it's outdated. Uh-oh. Almost immediate due to blow from blunt object. Oh. No way. Don't take a bow on that. Damn you, Edgeworth. I don't want to say not too crazy. I'll go for it. That's a second autopsy report. Man, him and his bows. Oh, it's gonna trigger me. I have to call this next witness. This poor innocent girl saw the murder with her own eyes. Uwu indeed. April, May, at your service. Wink. Yes, Your Honor, this is not good. So the murder occurred. I was in my hotel room, tee-hee. I checked in right after lunch, and this hotel is directly across from Fay & Co. law offices. Yep, that's right, big boy. Alright. This one's gonna go better this time. It's like 9 o'clock at night, looked out the window, you know, and then, ooh, I saw a woman with long hair being attacked. Mousy girl sitting in the defendant's chair. Then the woman, like, dodged to one side and ran away. But that girl, she caught up to her and she hit her. Long hair, she kind of slumped. The end, that's all I saw, every little bitsy witsy. Well, Your Honor, I see. It is remarkably solid testimony. I don't see any trouble to witness any... cross-exam, hello? No, no, no. Yes, always gonna cross-exam. Here we go. Nine o'clock at night, looked out the window, you know. And, oh, someone with long hair being attacked. Let's see. Let's press on this. Well, some people might say pretty, if that's your thing. And the person attacking her, okay. And you could see for sure? How'd you know she was the defendant? A girlish physique, women know these things. Oh, I just know, okay? I question it. That testimony stinks! I'm willing to bet that. Oh, I'll go for it. I'll say you're lying. What's the meaning of this? I'm clueless. My client, my fate. You would have noticed her clothes before noticing her physique. Far from normal to me, this is true. Neither of these things. I denied the murder. Yes, we do. Yep, yep. This may. Please omit nothing in your testimony. That's right. I'm sorry, Your Honor. I'll be a good girl. I promise. Testimony again, if you would. Almost had her. Alright, take two. Did see everything I did. The victim dodged the first attack and ran off to the right. And the girl in the hippie clothes ran after her. That weapon, I saw it. I did. That clock. That kind of statue-y clock? How did you know it was a clock? Hold up. Yes, I will definitely be pressing. Yes. Did see everything I did. That first attack ran off to the right, and the girl in the hippie clothes ran after her. With that weapon, I saw it. That clock. Yep. A clock? Yeah. You mean this clock? Yeah, let me present it. This may. Quite revealing. What do you, Mr. Naughty, Mr. Lawyer? Said the statue of the thinker was a clock. No way of knowing by looking at it. Exactly. Called this clock too, and he was found guilty of murder. Order, order. Miss May, can you explain how you know this was a clock? Oh. Objection. The witness saw the murder with her own eyes. That's all that's important here. Defense is trying to confuse the issue with trivial concerns. What? Yeah, objecting to the objection. Questions are all I have, Your Honor, and as you may recall, I've caught murderers with these questions before. Objection sustained. You may continue to question the witness. Whew. Huh? What? So what happens now? To answer my question, how did you know it was a clock? That's because I heard it. Yes, I heard it say at the time. Say, how did you hear it? No way. Not at all. No, Your Honor. Because she couldn't have heard it. You're at the hotel. Exactly right. You have proof that she could not? Amateurs, amateurs. In the courtroom, proof is everything. Without it, you have nothing, you are nothing. And I would like to propose a test to see if she really could have heard. Prosecution denies request. What? On what grounds? This is a trivial matter with no direct bearing on the case at hand. What? Not satisfied because... Do I say it again? I'll try the other one. The court, it is inconceivable. Oh, because the batteries are out. Yes, from the very beginning conversation. The batteries were removed, or the whole clockwork wiring was removed. So it's empty. Yup, yup. Just take a look right now. The clock is missing its clockwork. It's quite empty. And the court, the meaning of this? Clock was empty. It couldn't have rung. Hold on. Let me ever real attorney plays ace attorney. I'm changing my title one last time. I feel like I'm getting to the end here, but I want to make sure the title is matching what we're doing here. Okay. Therefore, this witness is a big, fat liar. Fat? Well, Miss May? Tisk tisk. Quite a show you've put on for us, Mr. Wright. He knew the clock was empty. Somehow, he knew. Afraid you've forgotten one thing, however. Indeed, the clock was empty. As you say, it can't ring. However, we must ask, when was the clockwork removed? If it was after the witness heard the clock, then there is no contradiction. It's alright, I got the phone call. No, I'm going to play the phone call. This is a big bombshell moment. Aha. Told me proof is everything? Well, I was listening, and now I'll show you the proof you like so much. Is... boom. Take that! Very cute cell phone. It's not mine. Contains a recording of a conversation she had with the victim on the day of the murder. Wahaha. Defendant's cell phone. This wasn't brought to my attention. Perhaps the detective overlooked it. Gotta say, I'm starting to feel bad for the big fella. Let's hear the conversation. Good. I should probably tell you, the clock isn't talking right now. Huh? It's not working? That's lame. Oh, so it's gonna be... I'm gonna ask, how in the world did you know about this conversation, Miss May? And then I put in the wiretap. And then everything explodes. Legally, not literally. So the quote is, how did you know that a weapon was a clock? Well, isn't it obvious? I saw that clock before. What store was that again? Oh, no, this is a custom clock. Yes, objection. Not seen the clock before. Made by Larry Butts. Boom. Any store ever. A friend of mine made that clock. Only 2 exist in the world. And the one that isn't here is in police custody. Impossible. Everything is sold in stores. Miss May, I think it's high time you went shopping for a better excuse. Ooh. Oh, excuse is not on sale today? Oh. Uh-oh. Oh, wow. What's it to you, porcupine head? Oh, boss fight engaged. That stupid clock doesn't matter, okay? She did it, and she should die for it. Die! Whoa, let's not get ahead of ourselves. This is a court of law, and the witness will remain calm. Her? Oh, okay. Oh ho ho, silly me. Did I, like, lose it? I guess I did, teehee. Okay, let me ask. Tell me, how did you know the weapon was a clock? You know, this behavior. Okay, this is it. Yes, Your Honor. Allow me to explain how I see the truth of the matter. Miss April May, you knew the weapon was a clock because you had heard about it. Mm-hmm. She heard. That's correct. No other way she could have known it was a clock other than the wiretap. Boom. Take that! Have a look at this. Miss April May, you were tapping the victim, Miss Mia Fay's phone, were you not? Oh. Your Honor, this is irrelevant. I'm not entirely sure that is. Objection overruled. This is very relevant, good sir. Told me that a witness was in possession of a wiretap. It's outrageous! The defense truly claimed the witness was tapping her phone? Absolutely. Even if that was the case, which it's not, you still have to prove one thing. Did the victim ever say that the weapon was a clock on the phone? Can you prove that? I think not. Oh yeah? I think I can. It's simple. What? Here's my proof. Proof that the victim said on the phone the weapon was a clock is... The victim said... So it's what Mia said... What? Huh? Proofs that the victim said on the phone the weapon was a clock. It's either the phone or the wiretap. It's got to be the wiretap. What's that saying? Because we already heard the phone conversation, so it has to be on here. I guess I'll try the phone. Oh, yeah. So he's gonna say it. Yeah. That's how you knew the thinker was a clock. Yeah. See, I thought we already listened to the phone, though. Honor, this is ridiculous. Your Honor, look at the witness's face. Does she seem amused to you? The defense demands an answer. Answer the question. Did you tap her phone? Miss May. Shut up, all of you. What gives you the right to talk to me like that? You lawyer? Uh-oh, she's crashing out again. It's no fair. All of you ganging up on me like that. Oh, so I'm the bad girl. Is that it? Is that it? Huh? That did it. The court's seen the real Miss April May now. Got to deal the final blow. Why the wiretap? Answer the question. Have to. Isn't tippity tapping or irrelevant? What's her to say? Miss May, you were tapping the victim's phone. Hard to call that irrelevant. Even though you tapped her phone? Huh, I just see her pull that off. Mr. Lawyer, I saw that evil grin. You were probably thinking I'd like to see her pull that off, weren't you? Damn, she's good. Well, you're not the first man who's thought that. And of course I can, and will. Can't be serious, no way. Way, I say, way. Oh, and I assure you I'm serious, Mr. Lawyer. Okay, so the killing happened around 9 o'clock at night. Why, that's just when I was getting room service from the sweet bellboy. Room service? Iced coffee, I believe it was. Iced coffee, you know, like normal coffee, but cold. If you don't drink it quick, the ice melts, and then you have regular cold coffee. Iced coffee. Think I'm making this up? Ask the bellboy. Ergo, the witness was not on the scene at the time of the murder, but we're not alleging that. At least I'm not alleging that. Great displeasure to inform you that the witness appears to have been tapping the victim's telephone. However, that is a separate crime with no bearing on the current case whatsoever. Her testimony stands. She saw the defendant, Maya Fey, commit murder. No. They're going to just let her walk away? There's no way I can win this unless I tie Miss May to the murder somehow. Well, does the defense have anything to say? Well... maybe he saw through the window. Oh. Bellboy is very relevant, good sir. So I hold that the wiretapping had nothing to do with the killing. However, if you'd agree to one condition, I'll consent to calling this witness. Condition, if Miss April May's alibi is not called into question after you examine the bellboy. Yep. I accept. Understood. I accept your condition. Fool, you fell right into my... you've activated my trap card. Very well. The court calls Hotel Bellboy to the stand. He came to serve us. Okay. Listening for timing. Last we heard was 9 o'clock. Head bellboy at Gatewater Hotel. Oh, call after 8 in the evening. Okay. Ice copy to be brought to her room at 9 on the dot. Precisely the requested time. Miss May herself. So he did not see anything. Let's see my... Okay. Nothing to use so far. I want to press him on this point here. 9 on the dot, you say? Yes. Confirmed that detail several times. She was watching a program on the TV and wished to drink after she finished, sir. 9 o'clock, the time of the murder. Precisely the requested time. Most definitely 9. How can you be so sure? Oh, bellboy, tee-hee, I'd like iced coffee at exactly 9. Something like that. Therefore, I knocked on her door at the crack of 9, sir. Why should you be so particular about the time? Absolutely. Very certain. Well, when I brought the room service, sir, the guest, sir, favored me with an embrasser. Oh. French for embrace? It's French for kiss. But not a French kiss, more of a peck on the cheek. She'd have done that. I believe perhaps she was momentarily swayed by my prim demeanor, sir. Moment I shall never forget. Sounds pretty fishy to me. I think she was up to something and wanted him to remember her. Is that it? Uh-oh. Finally, you understand. This bellboy has absolutely no reason to lie. Now, if you have any decency, you will end this rather tedious cross-examination here. Well, it's a bit tedious. Witness may leave the stand. No, not yet. One last question. Let me ask one last question. Gone on long enough. Now, Mr. Edgeworth. Alright, Mr. Wright, I'll give you one more question, that's all. Really it now, it's my last chance. What do I ask him about? That maybe she checked in with somebody? Oh boy. Check in, room service, or bed making. Let me ask bed making, because I want to get some insight of him being in the room itself, because I want to figure out if someone else was staying there with her. Okay. Hello, now, Mr. Edgeworth. Defense's question. Yes, well, it was quite like any other day's bed making. I changed the sheets, the pillowcases, and then I proceeded to make the bed. Had to bring pillows for 2, of course, but they were quite light, you see. Uh-huh. Got him. Bellboy, what did you just say? Yes, pillows are light, sir. Bellboy, tell us the truth now. Was someone else staying in Miss May's room? Uh-huh. I object. That was objectionable. Overruled. Witness will answer. Yes, I see. Why did you not mention this in your testimony? Well, sir, you didn't ask. Nice try. That's the sort of thing you're normally supposed to mention. Yes, quite indeed. It was the, good barrister there. Mr. Edgeworth. Uh-oh. He asked me not to mention it if I wasn't specifically asked. Uh-oh. You fool. I've done it. I've won. Well, not quite yet. Twin room with a man, correct? Yes, sir. You brought them room service. You didn't see that man in the room? That's right, sir. Your Honor, we have just learned of another person involved who may have been the murderer. In light of this new fact, I hold that it's impossible to judge the defendant. Wouldn't you agree, Mr. Edgeworth? And who, Mr. Wright? Who is this other person? Simple. It was... the other person was her! No. The man was Miss May. Your Honor, as has been previously revealed, Miss April May was tapping the victim's phone, yet Miss May herself has an alibi at the time of the murder. However, that does not clear the man that was with her. The bellboy saw no one else in the room at the time of the murder. My, what a convenient little setup, but it's too late. Too late? I suppose you'd like it if it was too late, wouldn't you? After all, it was you who hid the presence of the other man from this court. Oof. Upstart. Amateur. These accusations are ludicrous. Enough. The court acknowledges the defense's argument. Expect the prosecution and defense to look into this matter fully. Am I understood? Yes. Yes, Your Honor. That is all today for the trial of Maya Fey. Court is adjourned. That's right. You're amazing in there. Alright. got out of court. I'm saving. That's going to be it for today. Oh, man. Back to the beginning. Boom. There it is. Real attorney plays Ace Attorney. I don't know if anyone's still in here. Sounds like everyone dipped out, but that is all good. Hey, I appreciate y'all for tuning in. First ever stream. We're going to be back again next weekend, next Sunday afternoon. Don't have an exact time yet. I mean, we could tentatively say 3 o'clock like today, but might go a little later. We'll see. But yeah, no, definitely. I think it was a good time. Some great information that was shared, but I am so hungry now. Let me do this. Let me sign out this way. Yeah, I'm so hungry. So, and it's dark out now, so we'll see. Maybe I go get a burger, but I got some leftovers here. We'll go kill it. But yeah, appreciate y'all, and yeah, welcome to the new era of live stream Gen Z Attorney. So, yeah, I will see you all next weekend, next Sunday afternoon.